And hello, I'm Dan DeRose with 19 News, and welcome to our continuing coverage of Justice for Julian. This is the Bianca Ellis murder trial. Of course, the facts will reiterate them. It was June of last summer, so 2024, that Margot Wood and her 3-year-old son were simply grocery shopping at Giant Eagle in North Olmsted when they went out to the parking lot and they were viciously attacked by Bianca Ellis. We can say that because even her attorneys in court admit that she is responsible for the murder of Julian Wood. The 3-year-old little boy was stabbed in the face and then stabbed in the back. Margot, his mother, was stabbed once in the shoulder. She survived. Julian did not. Now, the facts are pretty immense that there is surveillance video of Bianca Ellis stealing the knives from Volunteers of America, walking into Giant Eagle, and once she spotted Margot and Julian, she follows them out to the parking lot and carries out the attack. She did not know the family. They did not have any kind of altercation inside the store. Now, her attorneys say this case comes down to one thing. Was Bianca Ellis insane at the time of the attack? That is why they have pleaded not guilty by reason of insanity. It will be up to the jury to come up with their determination. We have heard from multiple doctors, one paid for by the state, one paid for by the defense. The defense psychiatrist said that she felt, in her professional opinion, Bianca Ellis was insane at the time of the murder. The state's doctor, who happens to actually be a teacher, a former teacher instructor of the defense's psychiatrist, he took the stand both Friday and then again today. Remember, Monday was Columbus Day. He said, in his opinion, she was not insane at the time of the attack because of everything she was able to do leading up. Go steal the knives. She's not talking to herself. She's not having delusions. You don't see her referencing a delusion. And so in his professional opinion, she knew what she was doing. Let's remember, Bianca Ellis has had mental health, and everyone, all of the experts that got up there said that this is not a debate of whether or not she has schizophrenia. She has had it for approximately 10 years. It's whether or not that schizophrenia developed and caused her to have delusions and not know that murdering 3-year-old Julian was wrong. According to the state's doctor, Dr. Knopfsinger, he interviewed her for more than 3 hours a year after the attack, and she was never able to communicate to him, according to the testimony we heard, that she did say that she blacked out and she doesn't remember. But according to Dr. Knopfsinger, that's not the same as having a schizophrenic episode leading you to murder someone without knowing it's wrong. Simply blacking out, according to the doctor, is blanking out, is not a symptom of schizophrenia. The reason we're coming to you live is that we are about to get to jury instructions. All of the testimony is done. The state has rested, the defense has rested, and the jury was sent on a short recess while they discussed what items were entered in as evidence on the official record, meaning video, pictures that the jury would be able to review if they wanted to once they get to deliberations. Coming up in just about a minute, and I do see the judge in the courtroom. We're going to be able to take this to you live. Now, the judge has been fairly restrictive about what we could and couldn't show live. We would not let us show testimony during the week live as it was happening. We could show all of the testimony at the end of the day, but he was not allowing us to do it live. He has given us permission to show jury instructions, which we are about to get. I just want to listen in. To make sure we haven't gotten there quite yet, we are going to live broadcast here the jury instructions. The judge is going to be very clear on each count. Remember, she is facing a murder charge for Julian Wood, an attempted murder charge for stabbing Margot Wood. And there we see Bianca Ellis. She has been fairly emotionless throughout this entire time, including when they put up the autopsy photos of poor little Julian Wood. She glanced up at the photos several times, probably 15, 20, 25 times. She would look at the autopsy photos and then glance back down and look back up at the photos. But we have reached the point to where we are going to get jury instructions, and the judge has said they will do jury instructions, which probably won't take but 10, 15, 20 minutes. They are going to take a lunch break, and when they come back from lunch, it will be time for closing arguments. We will also broadcast closing arguments live as they happen, because once that is finished, this case will be in the hands of the jury. Earlier, late last week, we had our defense analyst, Jared Klebanow. He was a part of our Dark Side of the Land podcast. Highly recommend you watch that. Potentially even on the lunch break would be a good review to hear his analysis and how difficult it will be for the jury to sit in that room and come to a determination of not guilty by reason of insanity. You know that she is responsible for the murder. They are not denying that. So, did the defense do enough to show that she was mentally unstable? Not just unstable, but to the point of being insane at the time of the attack. I've got to tell you, the state's doctor who interviewed her for 3 hours, he was on the stand for hours at the end of Friday, another 3 hours this morning. He made a very compelling argument, and in fact, while we wait for the jury to come back in, I want to play for you some of his testimony this morning when the defense was trying to poke holes in his diagnosis that she was not insane at the time of the murder. Take a listen.
She didn't stab anyone on purpose, but it was due to a misunderstanding in her brain.
That was one of the things she told me, yes.
And she said that something took over and controlled her.
That was one of the things she said, yes.
But you said these were self-serving and not a product of a mental illness, correct?
I didn't say self-serving. I think that they lack clarity. We discussed the offense for 70 minutes, and she told me many things, and I tried to kind of ask a series of questions to clarify exactly what her thinking was.
She also stated that she felt things like anxiety, as you noted in your report, correct?
Yes.
She considered self-harm, correct?
Yes.
She said she lost body control, correct?
That's one thing she told me, yes.
She said she had visions of dying planets, the black moon, correct?
That's what she told me. Yes.
Satan killing her, telling her to kill herself, correct?
That's what she told me.
And hearing Satan's voice, correct?
At some point, yes.
Yeah, she said she felt overthrown by a monster and a strong spiritual presence. You remember that in the interview?
That's one thing she told me on June 12th of 2025, yes.
But yet you say these are signs that, these are not signs that she was suffering for a serious mental defect during the time of the incident?
No, I think we all agree she had the threshold severe mental disease. So we have what she's telling me on June 12th, 2025, more than a year after the offense. And that's one piece of information. But we look at that, we compare it to what she said or did at the time of the offense on June 3rd, 2024, as documented in the police records, all the video, the witness statements. What she tells me on June 12th of 2025 is in fact largely uncorroborated by the contemporaneous evidence.
That was the doctor testifying that the evidence in the video, she's not acting like someone who's insane, she's not talking to herself, she's not motioning like she's having a hallucination. The jury is back in the room. It is time for jury instructions, which we are going to bring to you live in their entirety. Let's listen in.
Again, you won't have notebooks because it's not evidence, but it is the opinions and the thoughts of each party about the factual basis that came through the witness stand here. And then I'll give you some final charging arguments or instructions to go back. So again, just giving me an opportunity to speak to all of you. Some of the things that I'll share with you are the charges of the court. So members of this jury, it now becomes my duty to instruct you on the law that you're going to apply to this case. The very beginning of our time together, I told you that the court and the jury have very separate functions. You're going to decide the disputed facts. I provide the law, which you're going to begin to use when you go back with your deliberations. You're to take this instructions as a whole. The instructions are to be taken and read as a whole. So there are some definitions that I define in maybe the first count that are used in all the other counts, or maybe in some separate counts. So you'll see as I read to you the counts that you will also be using all the instructions as a whole. So you all swore an oath to us, so it's your sworn duty to accept these instructions and to apply the law as I give it to you. This you're required to do apart from any notion or any opinion of any kind which you may have as to what the law is or what the law ought to be. It follows that in strictly keeping with your oath, that you refuse to be influenced by considerations such as sympathy or bias or prejudice for or against either the state of Ohio or Miss Ellis in this case. I told you that a criminal case begins with the filing of that indictment that I read to you. It's not evidence. We don't use it other than to inform you. That indictment informed Miss Ellis that she had been charged with a specific number of crimes. It cannot be considered for any purpose whatsoever in your deliberations. You're instructed that the opening statements that you heard and the closing arguments that you'll hear this afternoon do not constitute evidence. You must not speculate as to why I may have sustained an objection to any question or what the answer to such question might have been. And you must not draw any inferences or speculate on the truth of any suggestions included in a question that was not answered. Now, I've defined for you and read for you reasonable doubt, so I'll read it to you again. Every person accused of an offense is presumed innocent until proven guilty by evidence beyond a reasonable doubt. And that burden is on the state of Ohio. So the legislature has defined beyond a reasonable doubt, or reasonable doubt, as follows. Now, reasonable doubt is present when you as jurors, after you have carefully considered and compared all the evidence, that you cannot say that you're firmly convinced of the truth of the charge. Reasonable doubt is doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of the person's own affairs. Now, Miss Ellis claims an affirmative defense of not guilty by reason of insanity. So insanity, the definition, the plea of not guilty by reason of insanity raises the issue of the insanity of the defendant at the time of the commission of the act. I like to pause and just say, interchangeably, I use the word defendant. Now, obviously, that's Miss Ellis. I show no disrespect to her. The instructions that I give you, I may interchange both Miss Ellis or the defendant. That's just a title given in the legal definition. So I wanted to say that to you and to make sure that it's not anything lesser when I call her Miss Ellis or I call her the defendant. So again, I'll go back to that. The plea of not guilty by reason of insanity raises the issue of the insanity of the defendant at the time of the commission of the act. And defined, to establish the defense of insanity, Miss Ellis must prove by the greater weight of the evidence that at the time of the offense she did not know, as a result of a severe mental disease or defect, the wrongfulness of her act. Now, a mental disease or defect is severe if it is serious, major, or extremely intense. And I'll reiterate, a person is insane and not responsible for criminal conduct if at the time of her act or acts, A, she had a severe mental disease or defect, and B, as a result, she did not know the wrongfulness of her act or acts. It is the defendant's burden to prove the defense of insanity by a preponderance of the evidence. I gave you that definition as well. So preponderance of the evidence, again, is the greater weight of the evidence. That is evidence that you believe because it outweighs or overbalances in your minds the evidence opposed to it. Now, a preponderance means evidence that is more probable, more persuasive, or of greater probative value. Again, it's the quality of the evidence that must be weighed. Quality may or may not be identical with quantity or the greater number of witnesses. Now, in determining whether or not the defense of insanity has been proved by a preponderance of the evidence, you should consider all the evidence bearing upon that defense, regardless of who produced it. If the weight of that evidence is equally balanced, or if you are unable to determine what side of the defense has that preponderance, then the defendant has not established such defense. If you find that the state failed to prove beyond a reasonable doubt any element of the offenses charged in this indictment, you must find the defendant not guilty. Such a finding of not guilty would complete your duties and you would return a verdict of not guilty. However, if you find that the state proved beyond a reasonable doubt that the defendant did commit the act or acts as charged, you must proceed to determine whether the defendant was insane at the time the act was committed. Again, insanity. The plea of not guilty by reason of insanity, it raises the issue of the insanity of the defendant at the time of the commission of the act. And to establish that defense of insanity, Miss Ellis must prove by the greater weight of the evidence that at the time of the offense, she did not know, as a result of a severe mental disease or defect, the wrongfulness of her act. It is not a defense that the defendant's reason at the time of the offense was so impaired that she did not have the ability to refrain from doing her act or acts. An act committed under stress or under the stress of motive, impulse, emotion, rage, or passion, however strong and apparently uncontrollable, is not an excuse for an offense by a person not otherwise insane as previously defined here in these instructions. In this case, as in all other cases, again, it's the quality of the evidence that must be given primary consideration by each of you. The quality of that evidence may or may not be commensurate with the quantity of the evidence. That is, the number of witnesses or exhibits that have been presented. Now, whenever reference is made by the parties to evidence on which this case is to be decided, you, the jury, will understand that we mean testimony from the witnesses from this witness chair, exhibits that I've admitted during this trial, and any facts agreed to by the counsel. Now, those facts I've defined to you as stipulations. Just because something has been discussed here at the witness chair or by witnesses here, I may not have allowed the evidence to come in. as far as an exhibit. Sometimes lawyers use exhibits to be helpful, and they don't offer them. So I'm saying all that to you so when you go back, if you don't have an exhibit that you're looking for, it's not an exhibit being asked for you to consider. You'll use the evidence of the witness's testimony when you do begin to weigh your decision on this case. So again, all the exhibits I will send back with you that I have allowed or that have been offered by the parties. Now, that evidence may either be direct or circumstantial, or it could be a combination of both. Direct evidence is testimony. It's given by a witness who has seen or heard the facts to which that witness has testified. It includes the exhibits that I've accepted as evidence during the trial, and again, the stipulations. That's all known as direct, positive, or eyewitness testimony. Now, it's not always possible to ascertain the truth by evidence of this direct character, and thus the law does permit the introduction and consideration of what is called circumstantial evidence. Now, by circumstantial evidence, we mean proof of certain facts and circumstances from which you as the jury may infer other connected facts, which usually and reasonably follow according to the common experiences of humankind. You are instructed, however, that you are not permitted to base one inference upon another inference. Each inference must be predicated or based upon a proven fact or facts. Two or more inferences may be drawn from the same proven facts, or additional facts and evidence, or circumstances and evidence. In the absence of direct evidence, circumstantial evidence by itself may justify the finding of guilty. Now, I'll give you this example of circumstantial evidence and then kind of tie in inferences on that as well. I know it was discussed just briefly during our voir dire about a factual basis. So you'll hear this factual basis, but I'll go a little bit deeper. So let's assume in the very near future here in Cuyahoga County, you retire to go to bed at night. You look outside, you see the ground is clear. You wake up in the morning, and you find that the ground is covered by a blanket of snow. All right, now you did not see it snow, but from the fact, right, there's a fact that you find a blanket of snow on the ground that day, you have the right to infer, as a circumstance, that it snowed last night. You could also conclude that at some point during the night, it was cold enough to snow, right? So those are two inferences, right? You don't know that it got below 32 degrees. You didn't see it snow. But those are two inferences off the one fact, the fact that you see it snowed. So you can do that, two inferences off of one fact. However, what you cannot do is from that evidence, you cannot infer that it's going to snow tomorrow, right? That's an inference that's not on a fact. So the law, again, makes no distinction between the weight given to either direct or circumstantial evidence. It only requires that the jury, all of you, after weighing all the evidence, must be convinced of the guilt of the defendant beyond a reasonable doubt. Circumstantial and direct evidence inherently possess the same probative value, and in some instances, as I said, certain facts can only be established by circumstantial evidence. Now, I gave you the credibility of witnesses. We talked a little bit about that definition, so I'll give it to you again. You being the judges of the facts are also looking at the credibility or believability of each witness that came up here and testified. And then you assign the weight of that evidence to those witnesses. To weigh or determine the greater weight of the evidence, you must consider the credibility and the believability of the witnesses who testified in this case. You will use the test of truthfulness that you use in your daily lives. And again, that test, the test includes the appearance of each witness upon the stand, the witness's manner of testifying, the reasonableness of the testimony, the opportunity that that witness had to see, hear, and know those things about which the witness testified, and the witness's accuracy of memory, their frankness or lack of it, their intelligence, their interest and bias, if any, and then together with all the facts and circumstances surrounding the testimony, you then look at the credibility of the witnesses. Use this test and these tests and then assign to each witness testimony such weight as you think is proper for their testimony. Again, I said to you, you are not required to believe the testimony of any witness simply because the witness was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to decide what testimony to believe and what testimony not to believe. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. Now, Miss Ellis did not testify in this case. And ladies and gentlemen of this jury, it is not necessary that Miss Ellis take the witness stand and testify in her defense. The defendant has a constitutional right not to testify. The fact that she did not testify must not be considered by you for any purpose whatsoever. Now, I've read to you multiple counts, and I'll charge you with each of those counts in a moment. But because there are multiple counts, if you find that the state proved beyond a reasonable doubt all the essential elements of any one or all of the offenses as charged in the indictment, and the defendant failed to prove by a preponderance of the evidence the defense of insanity, your verdict must be guilty according to your findings. And you'll indicate that in your verdict forms. If you find that the state proved beyond a reasonable doubt all the essential elements of any one or all of the offenses as charged in the indictment, and that defendant proved by a preponderance of the evidence the defense of insanity, then you must find the defendant not guilty by reason of insanity according to your findings. And then you'll indicate that in your findings on your verdict form. And if you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of any one or all of the offenses charged in the indictment, your verdict must be not guilty to such offense or offenses. Again, consider each count separately. So the charges set forth in each count in this indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately. And you must state your findings as to each count, uninfluenced by your verdict as to the other count. The defendant may be found guilty or not guilty by reason of insanity, or not guilty of any one or all of the offenses charged. With the exhibits that will go back with you, you'll have the opportunity to use the Mondo pad in the jury room to view any of the evidence that we provide to you that may be video related or pictures as well. And we'll make sure staff shows you how to use that when you go back there. But you will have with you in the jury deliberation room the verdict forms that I'll give to you this afternoon, all the exhibits that have been offered and admitted by myself into evidence during the course of this trial. And during your deliberations, you should know that Rob, as our court reporter, will not be permitted to read back to you any portion of any of this trial testimony. Now, the time that we've indicated to you on the date of the offense in the indictment allegedly occurred has been previously stated for you, and I'll state it again on each count. It is not necessary that the state prove that the offenses were committed on the exact date as charged in the indictment. It is only sufficient to prove that the offenses took place on a date reasonably near the date claimed. So count one of this indictment is aggravated murder under Revised Code Section 2903.01a. The defendant, Bianca Ellis, is charged with aggravated murder in count one of the indictment. And before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 3rd day of June of 2024 in Cuyahoga County, Ohio, the defendant, Bianca Ellis, did purposely and with prior calculation and design cause the death of J.W., date of birth 10/29/2020. Purpose. Purpose is an essential element of the crime of aggravated murder. Result. A person acts purposely when it is her specific intention to cause a certain result. It must be established in this case that at the time in question there was present in the mind of the defendant a specific intention to cause the death of J.W., date of birth 10/29/2020. And additionally, purpose is a decision of the mind to do an act with a conscious objective of producing a specific result or engaging in specific conduct. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to herself, unless she expresses it to others or indicates it by her conduct. So how do you determine? The purpose with which a person does an act or brings about a result is determined from the manner in which it is done, the means used, and all the other facts and circumstances and evidence. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose or knowledge. Where an act is a crime, a good motive or purpose is not a defense. Prior calculation and design. It means that the purpose to cause the death was reached by a definite process of reasoning in advance of the homicide, which process of reasoning must have included a mental plan involving studied consideration of the method and the means or the instrument in which to cause the death of another. To constitute or be prior calculation, there must have been sufficient time and opportunity for the planning of an act of homicide, and the circumstances surrounding the homicide must show a scheme designed to carry out the calculated design to cause the death. No definitive period of time must elapse, and no particular amount of consideration must be given. But acting on the spur of the moment, or after momentary consideration of the purpose to cause the death, is not sufficient. Causation. Cause is an essential element of the offense of aggravated murder. Cause is an act which directly produces the death of another, and without which would not have occurred. And for each count, I will read each of the three options you have. So if you find that the state proved beyond a reasonable doubt all the essential elements of this offense of aggravated murder as charged in count 1 of the indictment, and the defendant failed to prove by a preponderance of the evidence the defense of insanity, then your verdict must be guilty according to your findings, and you'll indicate that in the verdict form. If you find that the state proved beyond a reasonable doubt, again, all the essential elements of the offense of aggravated murder as charged in count 1 of the indictment, and that the defendant proved by a preponderance of the evidence the defense of insanity, then you must find the defendant not guilty by reason of insanity according to your findings. You will then indicate that finding in your verdict form. And if you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of aggravated murder as charged in count 1 of the indictment, then you must find the defendant not guilty and indicate that in your verdict form. Count 2 is murder in the Revised Code section 2903.02a. The defendant, Bianca Ellis, is charged with murder. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on and about the third day of June of 2024 in Cuyahoga County, Ohio, the defendant, Bianca Ellis, did purposely cause the death of J.W. 10/29/2020. The term purpose I've defined for you, and it's the same definition in this charge in count 2. Cause. The state charges that the act or failure to act of the defendant caused the death of J.W. 10/29/2020. Cause is an essential element of the offense. Cause is an act or a failure to act which in a natural and continuous sequence directly produces the death of a person, and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act or failure to act. The defendant's also responsible for the natural and foreseeable consequences or results that follow in the ordinary course of events from the act or the failure to act. There may be one or more causes of an event. However, if a defendant's act or failure to act was one of the cause, then the existence of other causes is not a mere defense. Intervening causes. The defendant is responsible for the natural consequences of the defendant's unlawful act or failure to act, even though death was also caused by the intervening act or failure to act of another person or agency. Independent intervening cause of death. So if the defendant inflicted an injury not likely to produce death, and if the sole and only cause of death was a natural cause or fatal injury inflicted by another person, the defendant who inflicted the original injury is not responsible for the death. And again, in count 2, if you find that the state proved beyond a reasonable doubt all of the essential elements of this offense of murder as charged in count 2 of the indictment, and the defendant failed to prove by a preponderance of the evidence the defense of insanity, then your verdict must be guilty according to your findings and indicated on your verdict form. If you find that the state proved beyond a reasonable doubt, if you find that the state did prove beyond a reasonable doubt all the essential elements of this offense of murder as charged in count 2 of the indictment, and the defendant proved by a preponderance of the evidence the defense of insanity, then you must find the defendant not guilty by reason of insanity according to your findings and indicated in your verdict form. And then the third, if you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of murder as charged in count 2 of the indictment, then you must find the defendant not guilty, and then you'll indicate that in your verdict form. Count 3 is charged in murder in the revised code section of 2903.02b. And before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the third day of June of 2024, and in Cuyahoga County, Ohio, the defendant, Bianca Ellis, did cause the death of J.W., date of birth 10/29/2020, as a proximate result of the offender committing or attempting to commit an offense of violence that is a felony of the first or second degree, to wit, felonious assault and or endangering children. Again, the term cause has been previously defined, and the same applies herein. The underlying offenses in this count are felonious assault and endangering children. The elements of felonious assault I'll define for you in counts 4 and 8. The elements of endangering children I'll define for you in count 5, and those definitions will apply in count 3. And so if you find that the state proved beyond a reasonable doubt, again, all the essential elements of this offense of murder as charged in count 3, then of the indictment, and the defendant failed to prove by a preponderance of the evidence the defense of insanity, then your verdict must be guilty according to your findings. If you find that the state proved beyond a reasonable doubt all of the essential elements of the offense of murder as charged in count 3, and that the defendant proved by a preponderance of the evidence defense of insanity, then you must find the defendant not guilty by reason of insanity. Again, either of those verdicts would be indicated in your verdict form. And then lastly, if you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of murder as charged in count 3 of the indictment, then your verdict you must find the defendant not guilty. You will then indicate that finding in your verdict form. I indicated count 4 and 8 are both felonious assaults, so I'll read this charge as one, indicating just the differences in 4 and 8, 4 being felonious assault against J.W., 102920, and in count 8, the felonious assault would be against Margot Wood. So in this count, 290311A1, Ms. Ellis is charged with felonious assault in counts 4 and 8. Before you can find the defendant guilty in any one or both of the counts 4 and 8, you must find beyond a reasonable doubt that on or about the 3rd day of June 2024 and in Cuyahoga County, Ohio, Ms. Ellis did knowingly cause serious physical harm in count 4 to J.W. and count 8 to Margot Wood. Again, the cause definition I've defined for you. So here's the definition elements. Knowingly. A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist, when knowledge of the existence of a particular fact is an element of an offense. Such knowledge is established if a person subjectively believes that there is a high probability of its existence and then fails to make inquiry or acts with a conscious purpose to avoid learning the fact. So how do you determine this? Because you cannot look into the mind of another. So knowledge is determined from all the facts and circumstances and evidence. You'll determine from these facts and circumstances whether there existed at the time in the mind of Bianca Ellis an awareness of the probability that she would cause serious physical harm to J.W. or Margot Wood. So what is serious physical harm to person? What does that mean? And it would be any of the following. 1, any mental illness or condition of such gravity as would normally require hospitalization or prolonged psychiatric treatment. Number 2, any physical harm which carries a substantial risk of death. Number 3, any physical harm which involves some permanent incapacity, whether partial or total, or which involves some temporary substantial incapacity. Number 4, any physical harm which involves some permanent disfigurement or which involves some temporary serious disfigurement. And then finally, number 5, any physical harm which involves acute pain of such duration as to result in substantial suffering, or which involves any degree of prolonged or intractable pain. Substantial risk means a strong possibility, as contrasted with remote or even a significant possibility, that a certain result may occur or that certain circumstances may exist. And so for these 2 counts, if you find that the state, again, independently each count, proved beyond a reasonable doubt all the essential elements of the offense of felonious assault as charged in any one or both of counts 4 and 8 of the indictment, and that the defendant failed to prove by a preponderance of the evidence the defense of insanity, then your verdict must be guilty according to your findings and placed in your verdict form. Again, for these 2 counts, if you find that the state proved beyond a reasonable doubt all the essential elements of the offense of felonious assault as charged in in any one or both of counts 4 and 8 of the indictment, and that the defendant proved by a preponderance of the evidence the defense of insanity, then you must find the defendant not guilty by reason of insanity according to your findings. And then you'll indicate that in your findings on the verdict form. And if you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of felonious assault as charged in any or one or both of counts 4 and 8 of this indictment, then you must find the defendant not guilty, and you'll indicate that finding on your verdict form. Count 5 is endangering children under Revised Code Section 2919.22b2. As charged in count 5, before you can find Ms. Ellis guilty, you must find beyond a reasonable doubt that on or about the 3rd day of June of 2024, and in Cuyahoga County, the defendant, Bianca Ellis, did torture or cruelly abuse J.W. 10/29/2020, a child under 18 years of age, to wit, 10/29/2020. And furthermore, the violation resulted in serious physical harm to J.W. Abuse means any act that causes physical or mental injury that harms or threatens to harm the child's health or welfare. Child means any person under age 18 years of age or mentally or physically handicapped person under 21 years of age. And again, on this count, if you find that the state proved beyond a reasonable doubt all the essential element of the offense of endangering children as charged in count 5 of this indictment, and the defendant failed to prove by a preponderance of the evidence the defense of insanity, then your verdict must be guilty according to your findings. And you'll indicate that on your verdict form. Again, if you find the state proved beyond a reasonable doubt all of these essential elements of the offense of endangering children as charged in count 5, and that the defendant proved by a preponderance of the evidence the defense of insanity, then you must find the defendant not guilty by reason of insanity according to your findings, and indicate that on the verdict form. And if you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of endangering children as charged in count 5 of this indictment, then you must find the defendant not guilty, and you'll indicate your finding on the verdict form. There's a further finding on the verdict form, which I'll go through with you, and that's the cause substantial risk of serious physical harm. And only if your verdict is guilty of endangering children as charged in count 5, you then must decide beyond a reasonable doubt whether the violation did or did not result in serious physical harm to J.W. 10/29/2020. If your verdict is not guilty or not guilty by reason of insanity, you will not consider this issue. Again, the term serious physical harm to a person has previously been defined, and that same definition applies herein. And going now to count 6, attempted murder in Ohio Revised Code section, as noted, 2923.02 and 2903.02a. This charge is count 6, and before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 3rd day of June of 2024, and in Cuyahoga County, Ohio, the defendant, Bianca Ellis, did attempt to purposely cause the death of Margot Wood. The terms purpose and cause have been previously defined, and the definitions apply within. So, criminal attempt. A criminal attempt occurs when one purposely or knowingly does or admits or fails to do anything that is an act or omission or failure constituting a substantial step in a course of conduct planned to culminate in her commission of the offense. To constitute a substantial step, the conduct must be strongly corroborative of the actor's criminal purpose or knowledge. Preparation. Preparing, planning, or arranging the means for the commission of the crime does not constitute an attempt. Impossibility. It is not a defense to a charge of attempt that in retrospect, the commission of the offense, which was the object of the attempt, was impossible under the circumstances. And if you find the state proved beyond a reasonable doubt all of the essential elements of the offense of attempted murder as charged in count 6 of the indictment, and the defendant failed to prove by a preponderance of the evidence the defense of insanity, your verdict must be guilty according to your findings, and then you'll indicate that in your verdict form. If you find that the state proved beyond a reasonable doubt all the essential elements of the offense of attempted murder as charged in count 6 of the indictment, and the defendant proved by a preponderance of the evidence the defense of insanity, then you must find the defendant not guilty by reason of insanity according to your findings, and place that in your verdict form. And if you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of attempted murder as charged in count 6 of the indictment, then you must find the defendant not guilty, and you'll indicate your findings in the verdict form. All right, 2 additional charges. This one would be the attempted murder charge in count 7. The defendant, Bianca Ellis, is charged as noted in the revised code section. And before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 3rd day of June of 2024, and in Cuyahoga County, Ohio, the defendant, Bianca Ellis, did attempt to cause the death of Margot Wood as a proximate result of the offender committing or attempting to commit an offense of violence that is a felony of the 1st or 2nd degree, to wit, felonious assault. Again, those revised code sections are 2923.02, 2903.02b. The terms attempt and cause have been previously defined, and the same definitions apply herein. The underlying offense in this count is felonious assault. The elements of that offense I defined for you already in count 4 and 8, and that same definition apply herein. Again, if you find that the state proved beyond a reasonable doubt all the essential elements of the offense of attempted murder as charged in count 7 of the indictment, and the defendant failed to prove by a preponderance of the evidence the defense of insanity, then your verdict must be guilty according to your findings, and you'll then indicate your findings on the verdict form. And if you find the state proved beyond a reasonable doubt all of the essential elements of the offense of attempted murder as charged in count 7 in the indictment, and the defendant proved by a preponderance of the evidence the defense of insanity, then you must find the defendant not guilty by reason of insanity according to your findings and placed in your verdict form. And if you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of attempted murder as charged in count 7 of the indictment, you must find the defendant not guilty, and you will then indicate your findings on the verdict form. And then lastly, count 9, the defendant, Bianca Ellis, is charged with theft in violation of Revised Code Section 2913.02A1. And before you can find her guilty, you must find beyond a reasonable doubt that on or about the 3rd day of June of 2024, and in Cuyahoga County, the defendant, Bianca Ellis, did with purpose to deprive the owner, Volunteers of America store, of property or services of another permanently, appropriate a substantial portion of its value or use, or with purpose to restore it only upon payment of a reward or other consideration. Number 2, dispose of property so as to make it unlikely that the owner will recover it. And number 3, accept, use, or appropriate money, property, or services with purpose not to give proper consideration in return therefor, and without reasonable justification or excuse for not giving proper consideration. An owner means any person other than the defendant who is the owner of, or who has possession or control of, or who has any license or interest in that property or services, even though the ownership or possession, control, or license or interest is unlawful. And then finally, property. Property means any property, real or personal, tangible or intangible, and any interest or license in that property. Property includes but is not limited to cable television services, other telecommunications services, telecommunications devices, information services, computers, data, computer software, financial instruments associated with computers. Lots of definitions that don't apply here, but I'll continue to read them. Other documents associated with computers, or copies of documents, whether in machines or human readable forms. Trade secrets, trademarks, copyrights, patents, and properties protected by a trademark. Copyright or patents, financial instruments associated with computers, included but are not limited to checks or drafts or warrants or money orders, notes or indebtedness, certificates of deposits, letters of credit, bills of credit or debit cards, financial transactions, authorizations, transaction authorization mechanisms, marketable securities, or any other computer system representations of any of them. Services include labor, personal services, professional services, rental services, public utility services, common carrier services, and food or drink, transportation, entertainment, and television services. And then finally, consent. Consent may be either expressed or implied. Express consent is determined by the written or spoken words of the persons involved. Implied consent is determined by the facts, circumstances which surround those involved, including their words and acts, from which the jury may infer that consent was given to the defendant. And on this final count, if you find that the state proved beyond a reasonable doubt all the essential elements of the offense of theft as charged in count 9 of the indictment, and the defendant failed to prove by a preponderance of the evidence the defense of insanity, your verdict must be guilty according to your findings. And you'll indicate that in your verdict forms. If you find the state proved beyond a reasonable doubt all the essential elements of the offense of theft as charged in count 9 of the indictment, and the defendant proved by a preponderance of the evidence the defense of insanity, then you must find the defendant not guilty by reason of insanity according to your findings. Finally, if you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of theft as charged in count 9 of the indictment, then your verdict, you then must find the defendant not guilty and indicate that on the findings of your verdict form. And then, ladies and gentlemen, we're going to recess, but here's what I'm going to tell you. I've given you an opportunity to understand the instructions as they apply to all counts that you're going to deliberate on. I'm not charging you to go back and deliberate. So until I charge you with go back and deliberate, that means no discussions regarding this matter with anybody or having discussions outside regarding this matter. So please be mindful of your oath to all of us. With respect to our break, when we come back, again, the lawyers will have an opportunity to tell you what they believe the evidence presented in their closing arguments. Again, it's not evidence, and so I'll not provide you with your notebooks to take any notes as well. And upon finally those completions of those arguments, I'll charge you with a few jury instructions to go back and begin your deliberations. So again, please do not discuss this matter. We'll take an hour break. We'll call for you around 1:30, 1:35 to come back up. If we'd all rise for the jury, please. Thank you. Thanks, Ashley. All right, we'll be seated for a moment. All right, with respect to so far the reading of those charges under the jury instructions, does the state have any Any objections or comments that I need to address regarding so far what I've read? All right, thank you. Anything from defense? All right, thanks very much. We'll recess. Expect that you have everything in order. If you're going to use the Mondo pad, please make sure it works.
Good afternoon, Dan DeRose with 19 News. If you're just joining our coverage, you have been watching the jury instructions. It's a very dry process, but part of the necessary process to explain to the jury exactly what they need to consider, and especially as you see Bianca Ellis heading back for the lunch recess, when we are talking a case that involves a not guilty by reason of insanity. This is very touchy. You need to make sure the jury understands everything on every count. And as you heard, we are talking aggravated murder, attempted murder. There's even endangering a child. That's because it was an attack on a child. There was a theft charge because she stole the property, those knives from Volunteers of America. Now, what's going to be interesting is here we are on an hour-long lunch break. Once they come back from the lunch break, it will be time for closing arguments. They can vary in length, generally not going to last hours and hours. So we can surmise that the jury is going to have this case by mid-afternoon, and that's where we stand. We're going to welcome in, she has been a legal analyst for us for a number of cases. We're glad to have her back. Tara Coleman, a noted defense attorney here in the Cleveland area. It is good to have you back, Tara. How are you?
Thanks, Dan. I'm doing all right. Thanks for having me.
This is a rough trial, and for those of us that are joining us here on our 12:30 break, we are going to play some of the testimony, and I'm going to say it right now. This is a crime that involves the stabbing death of a 3-year-old child. There are no pleasant details here. This is a tough case all the way around. Tara, let me just ask you, as a defense attorney, what is the mood of the jury? They haven't heard closing arguments yet, but they know it's close. The end is close, and they're about to have this case in their hand. What is the jury thinking about right now as they head to lunch before closing arguments?
This case, the facts surrounding it are just so devastatingly heavy that I imagine the jury is obviously very solemn, and I imagine they are ruminating over the expert testimony from both sides.
And that's what's been interesting. The closing days of last week. Today is our first day of testimony. Yesterday was Columbus Day. We heard from 2 doctors, both psychiatrists, one hired by the defense, one hired by the state. The defense expert says she was clearly insane when she stabbed that child in the parking lot. The state's expert says she was not insane. Now, what's interesting about this is that those 2 psychiatrists know each other very well. In fact, the state's psychiatrist, Dr. Knopfsinger, he was an instructor of the defense's expert. I want to make sure I get her name correct. She was Dr. Sarah West. She was the state's expert, and she was also a student of the state's psychiatrist. So very interesting in this case. Tara, what
I caught
happens?
that in the reporting, but Dan, I have a quick question for you.
Yeah.
Was Knopfsinger also the initial expert in the state's first case, or just a rebuttal witness?
He was, in fact, he was a rebuttal witness, and we wondered why the state didn't call him before they rested. It's because they clearly had a strategy to bring him on after you got to hear from the defense's expert that says she was insane. The defense played a little strategy, a little chess match, and sort of said, well, if that's where the defense is going to end, and when we get to our rebuttal witness, here's our doctor who says she was not insane, that an insane person going through hallucinations would have been talking to herself. Obviously, there's no audio in the surveillance videos, but you don't see her lips moving. She's not having hallucinations to where she's reaching out and touching something or swatting something away. And so his expert analysis was that someone who is clearly has a mental deficiency here, just by simply saying, I blanked out, that's not what a person who's got schizophrenia says when they know whether it's right or wrong. He is trying to say that simply saying you blanked out is not a symptom of schizophrenia. So how does a jury handle this? You have one doctor who says she was insane, one doctor who says she wasn't.
It comes down to credibility. So they're going to be weighing, obviously, I'm assuming they got into these experts are paid, who is paid what. So it's going to come down to how you view the prosecution, the attorneys themselves, how you view the defense, the attorneys themselves, and how you view the expert witnesses themselves, because you're taking all of that in mind as you weigh credibility and who you're going to go with. You're also weighing the little intricacies of reasoning behind the opinions they're giving and what lands with you the most. Who do you think is most credible based on that reasoning?
And does it matter? And I'm going to play a little clip from today's Dr. Knopfsinger, and if I can get there, we'll see. But I want to ask you, does it help that the doctor who said she wasn't insane went last? Does that matter to a jury who they hear last?
I'm biased, but I honestly think the last word does carry weight. It's because when you go back into deliberations, that's just what's most fresh on your mind. So logically, you would think that's kind of going to be top of mind. It's going to be at the top of their notes. So it does matter. And I do see the strategy they went with there. One, this was an instructor, and calling him as a rebuttal witness, I think definitely was strategy.
And I'm going to try and, okay, let's listen to, there's two parts of Dr. Knopfsinger's testimony today. And I think, as Tara was saying, this is the lasting moment that's going to stick with the jury. The fact that you heard Dr. Knopfsinger last. Take a listen.
She didn't stab anyone on purpose, but it was due to a misunderstanding in her brain.
That was one of the things she told me, yes.
And she said that something took over and controlled her.
That was one of the things she said, yes.
But you said these were self-serving and not a product of a mental illness, correct?
I didn't say self-serving. I think that they lack clarity. We discussed the offense for 70 minutes, and she told me many things, and I tried to kind of ask a series of questions to clarify exactly what her thinking was.
She also stated that she felt things like anxiety, as you noted in your report, correct?
Yes?
She considered self-harm, correct?
Yes?
She said she lost body control, correct?
That's one thing she told me, yes.
She said she had visions of dying, planets, the black moon, correct?
That's what she told me. Yes.
Satan killing her, telling her to kill herself, correct?
That's what she told me.
And hearing Satan's voice, correct?
At some point, yes.
Yeah, she said she felt overthrown by a monster and a strong spiritual presence. You remember that in the interview?
That's one thing she told me on June 12th of 2025, yes.
But yet you say these are signs that, these are not signs that she was suffering for a serious mental defect during the time of the incident?
No, I think we all agree she had the threshold severe mental disease. So we had what she's telling me on June 12th, 2025, more than a year after the offense. And that's one piece of information. But we look at that, we compare it to what she said or did at the time of the offense on June 3rd, 2024, as documented in the police records, all the video, the witness statements. What she tells me on June 12th of 2025 is in fact largely uncorroborated by the contemporaneous evidence. as I lay out in the report, all the contemporaneous evidence, all the video from different sources, there's not objective signs that she's psychotic, disorganized, delusional, or having hallucinations. And you'd expect someone who's so mentally ill as to then commit a murder minutes later, there'd be outward signs of their mental illness. And in fact, there is not. There was no psychotic motive for the offenses which caused her to perceive that the offenses were right. And I say, again, based on what she told me during this interview on June 12th, that she experienced these various symptoms of mental illness at the time of the offense. And I list the symptoms: anxiety, consideration of cutting her arms, loss of control of her body, visions of herself dying, planets, a black moon, and Satan killing her. Visions about planets and the moon that were all black or killing somebody, and then Satan killing her. Hearing voices telling her to kill herself, feeling like she was overthrown by a monster that was stronger than me, the single voice of Satan telling her to kill herself, the strong presence from spirits, especially Satan, that stopped her from dropping the second knife. Even if you accept those that she experienced that, none of those symptoms would cause her to believe that committing the murder and the attempted murder of the victims was the right thing to do.
Very powerful testimony there from the psychiatrist who interviewed her for 3 hours a year after the incident. Tara, were you able to hear that?
I was, yes.
Walk me through why that is so important, that he's saying, okay, nobody is debating that she's mentally ill. Let's understand, anybody who thinks stabbing a child in the face and the back has clearly got a mental health problem. But having a mental health problem is not the same as being psychotic and insane at the time of the incident. What is he trying to explain there, and what's going to stick with the jury?
Yes. So because in order for the defense to adequately prove their defense of not guilty by reason of insanity, there are two prongs to that. One, that she did suffer from a mental illness. The second being that at the time of the act, she had the inability of knowing its wrongfulness, what's right from wrong. And so what they are focusing on, this is tricky, right? Because it almost seems to be a matter of control versus knowing right from wrong. It seems in that instance, at the time of the attack, her symptoms are telling her she can't control what she's doing. I think we saw that evidence of that in the plaintiff's case, and from the defense expert, that she needed this help and she couldn't control her actions. And so while that might be due to the mental illness, that is not the same as knowing right from wrong, regardless if you can control your actions or not based on your mental illness. And so what he is really trying to decipher here, is that right from wrong piece. I will say this also went a little stronger on the first piece as well. Because to me, I think both sides are I mean, she was mentally ill. I think we know that. I think it's just a matter of what the symptoms did to her at the time of the attack. And I think that this expert is talking about these other symptoms of anxiety and the psychotic symptoms to kind of undermine the seriousness of the symptoms at the time. So honestly, that part was, I could see that confusing jurors a little bit, focusing on that first prong.
And we have heard from Dr. Knopfsinger in his testimony last week. They keep using the term organized versus disorganized. Is someone that is having a psychotic episode, are they able to organize a plan, organize their thoughts? And that also seems to be what the jury is going to have to wrestle with. She goes to the police department that morning, claims that they stole her $700. That was the money she needed to be able to have a place to stay. The police tell her, we don't have your money. There was never $700 when we arrested you 4 days prior. That's when she gets angry, and she clearly, or The jury is going to have to ask themselves. She then devised a plan. She had nowhere else to stay. She had already tried in the months leading up to this to tell police that she had committed a murder and she needed to be arrested, sort of as if to be able to get help and have a place to stay. That didn't work in the past. So, as a jury member, does this look like somebody who was able to have the presence of mind to be organized enough to know, I can get a knife from Volunteers of America? I can then look for a victim by walking next door to Giant Eagle and then walking into Giant Eagle. Is she going to stab? She passes a number of people, but she chooses, and we've noted this here in our discussion, Julian is the first child that she saw. She walks by a number of adults at Volunteers of America, walking through the parking lot, walking into Giant Eagle, but Julian is the first child she saw. I'm kind of surprised that that didn't come up in court. Does that make any sense to you, or is that something as the defense or as the state you just can't bring up, that that was the first child she encountered?
That does make sense to me. And so, on the point of disorganization, that keeps coming up because that is a technical symptom of being psychotic, of the mental diagnosis. And disorganization, it truly means it's about the thoughts. Is it disorganized thinking? Are your thoughts jumbled? Is there disorganized speech? And so they are obviously going to talk about the lead up to the incident, which does seem very organized, right? To show that she didn't have that disorganization. However, it is key. It's at the time of that stabbing. Is she disorganized? Are her thoughts disorganized? Are they jumbled? And I will say, based on kind of the psychiatric interviews, it seems like there isn't that jumbledness there, but again, that lack of control, which I think will definitely cut against them. And you bring up a great point that this was the first child she saw. I noticed that too. And where my mind went on that is, okay, this is a person that we have seen pleading for help time and time again. And one part of it does make you wonder if that part was purposeful because she felt she had to do something so egregious um, as to really make that call heard. Again, that's obviously speculation, and we didn't get into evidence of that, but I do think it's notable that Julian happened to be the first child.
It is interesting, and boy, I would love to be able to sit in the jury deliberation room and to hear this discussion. Let's talk about this charge or this plea of not guilty by reason of insanity. When the jury gets this case, and for those of you who are joining us mid-process here, we are at lunch with the jury for the Bianca Ellis trial. Lunch is expected to get over in about a half an hour. At the end of that, the jury will come back in. Both the state and the defense will give their closing arguments. Tara, how long do you expect closing arguments to go in a case of this magnitude?
There might be a time limit set already, honestly. I'm not sure. Do you recall how long opening were?
Uh,
The opening
the
did?
opening
Okay.
arguments were maybe 15, 20 minutes apiece, both
I,
for the state and the
they're going to
defense.
be they're going to be about the same, and usually the prosecution would have a chance to come back at the end for a shorter time if they want that last word. So I think we would be looking around 20 minutes each side again, and then maybe 5 to 10 rebuttal.
And what does the message have to be? Let's put you as a noted defense attorney here in Cleveland. You're obviously not on this case. You haven't reviewed all the evidence. We understand that. Let's say you have to get up and you have to defend Bianca Ellis to that jury. What is your message?
Yeah, you're going to have to focus on just the severity of her mental illness and how anything you can lob onto within the reasoning from your expert opinions as to that wrongfulness aspect. And that's what really has to be hit home. Um, did she know what she was doing was wrong. And so your closing is going to have to undermine the testimony that makes you think, even though she couldn't control it, she might have knew right from wrong. So you'll have to undermine that. And then you will have to bolster up significantly that this person was not in their right mind. They could not decipher right from wrong. And therefore, at the time of the actual incident, not when she went and bought the knife, not when she went into the Giant Eagle circling and surveying, but at the time of the actual incident, did she know right from wrong in that moment?
It's going to be interesting, and I think back to, as you just said, the moment of, not the circling, not the following, not the standing in the entryway of Giant Eagle, the exact moment, and whether or not she was cognizant there. And we heard in the testimony from Margot Wood that I'm going to play here. We have 2 clips, and I'm going to warn you, this is very, very tough to listen to. This is a mother who mustered up the strength to walk into a courtroom where the killer is sitting right there. You would normally not hear me say that when we are covering a trial. Bianca Ellis is no longer an accused murderer. In the opening arguments, her own defense attorney said she has said through her attorneys that Bianca Ellis is responsible for the death of Julian Wood. That's why we're not calling her the accused murderer. She murdered Julian Wood. Again, it comes down to the question, was she sane when it happened? But as we play these 2 clips from Margot Wood, the mother, she is emotional. We did make an editorial decision to take out the instance that she talks about the stabbing, where Julian was stabbed in the cheek and the back. Just too tough to listen to and too tough to be out there. We also took out where she's talking about holding Julian in that parking lot as Bianca walked away and Julian and his severe injuries. But let's remind our viewers, in case they haven't seen and haven't been following this that closely, the heart-wrenching testimony of Margot Wood. And I tell you what, Tara, as we do this, I'm going to reset our shot, so we'll get you back in just as soon as we play this. Let's take again a listen to the testimony from Margot Wood very early last week.
So we were all going to go to the store, my mom, my daughter, Julian, and myself, okay? But my daughter fell asleep, and my mom said, let's not wake her, so it ended up just being Julian and I going. Usually around that time they have flower baskets outside. So he helped me pick out some flower baskets. And we went inside, bought some candies and things, and we did groceries. And then we went to the self-checkout. Yes, he remained seated in the car seat area, or not the buggy area, the seat. Yes.
Yeah. So when you were in the store, Mrs. Wood, did you notice anything strange?
No.
Did you notice anybody accost you or say anything to you or acknowledge you? Anything of that sort?
No.
So you continue to push your cart out of the store.
Yes.
And before you left the store, Mrs. Wood, did you notice anyone by you? Did you see anybody? Did anybody talk to you?
No.
Did you see other patrons in the store walk by you?
I did.
Did anybody stick out to you?
No.
When you were leaving, did someone say, hey, Margot, or acknowledge you, or had seen you, like that?
No.
All right. So you were minding your own business, going to your car?
Yes.
All right. So tell us, walk me through that. So you went down the aisle that your car was parked?
I did.
Okay. And if you could be so kind, were you parked face forward with your car, or had you backed into the spot?
Face forward.
Okay. And so at any time before you got to your car, did you notice anything?
No.
All right. So once you got to your car, what's the first thing you did?
Sorry. I went to open my trunk.
Okay.
And then I turned to my right. And I saw her coming towards us.
When you say her, who we've come to know that is?
Bianca Ellis.
We're going to stipulate, Mr. Mack, that Mr.
And she's in this courtroom here today, is she not?
Yes.
Thank you. Thank you for the stipulation, counsel. Go ahead, Mrs. Ward.
So I saw her coming, walking towards us, and I noticed she had a knife in her hand. And I said, "Oh no, Julian." So I had the car, I stood in front of the end of the cart, and I was trying to push him back he was still sitting in the cart. And she stabbed the back of a trunk of a car, and I got scared. But when I was pushing the car back, it fell over. And then she came at me. I'm sorry. She came at me. So
Incredibly tough testimony to listen to say the least. She would then explain the attack, and it was difficult to listen to. It was brutal, to say the least. And I'm trying to maybe pull up our second half of that testimony. We're going to listen to that. Tara Coleman is back with us, our defense analyst. Tara, we're going to play the second part of this testimony. It's just about 3-4 minutes long here, and then we'll bring Tara back in to discuss the impact on the jury that the mother's testimony, Margot Wood, had. Again, we made an editorial decision to cut out this mother struggling through the moments of her child being stabbed and then holding him as he was bleeding. We had heard from the medical examiner, deputy medical examiner, that the first stab to the cheek actually went through his jawbone and cut a portion of his carotid artery. So a lot of blood in that instance. And then the stab to the back actually went through 2 ribs, went in 4 inches, cut into Julian's lung, and also an artery in the lung. So he started bleeding internally as well. Here is the second part of the testimony from the mother, Margot Wood.
After she stabbed him in the back, what did she do next?
she just walked away. Like nothing. She just walked away.
Mrs. Wood, once you were experiencing this with Julian, were you calling for help?
Yes.
And were you in fact screaming for help?
Yes.
Did folks start to come around you?
They did.
And did there come a point in time that somebody came by and took Julian and tried to help Julian?
Yes.
Did she indicate at the time she was a nurse?
She did.
okay? And did other folks come and surround you and try to help you as well?
Yes.
And ma'am, where were you stabbed?
On the top of my right shoulder.
All right? And did you have to seek medical care?
I did.
Were you taken to the hospital as well?
I was in a separate ambulance.
All right. So, once the defendant walked away, did you see her again?
No.
And so, did there come a point in time that the ambulance came and took Julian away?
Yes.
And were you able to contact your husband to come to the scene?
I did.
All right. And did he come?
He did.
And did both you and Julian end up at the hospital
Yes.
in separate rooms?
Yes.
And did there come a point in time that you were then notified of his death?
Yes. Yes.
Mrs. Wood, while you were at the hospital, did they provide you medical care?
Yes.
And did you have to have any stitches or anything with regards to your injury?
I received 4 stitches.
And that was on your shoulder?
Yes.
All right. Mrs. Wood, with regards to your injury, do you have a scar as a result of that stab wound?
Yes.
Mrs. Wood, did you know Bianca Ellis before June 3rd of 2024?
No.
Had you ever seen her before?
No.
Had you had any communications with her?
No.
Thank you. No further questions at this time.
Any cross-examination? Thank you.
As you saw there, it's just very tough to listen to a mother having to recount all of that. Want to make a couple of points. We're bringing back in Tara Coleman, our defense analyst here in Cleveland. Tara, there's 2 points. In the first portion of the testimony, Margot Wood talked about, and I don't think you had quite called back in yet, but Margot Wood talked about that as she turned to her right, she saw Bianca Ellis walking towards her. She saw the knife, and she said to Julian, "Oh no." And Bianca stabs the trunk of a car before she gets to Julian and Margot. And you talked earlier about that moment of, and that's what the defense is going to have to try and place in the minds of the jurors, that who stabs a car, the trunk of a car before you get to her. Is that what you're talking about when you're trying to say, we've got to show the jury that she was insane in that moment of, not the getting of the knife, the stealing of the knife, not the walking around Giant Eagle, but she stabbed a car and then stabbed 2 humans, 2 people? Is that what you're implying?
Absolutely. If I'm the defense, I'm harping on that in my closing argument. Also, the fact she walks away as if nothing happened, tricky, that could cut one of both way, 2 ways. But as a juror, mentally, you almost want to believe that no one could do this, but for being insane, but for not knowing the wrongfulness of it. So the fact that she walks away as if nothing happens, it could be an indication that she did not know what she had just done, what was right from wrong in that time, due to her mental illness.
Because we could say that a rational person, and again, we're trying to get away from what had just happened, no rational person would do. But you would think that if you had just committed a crime like that, a person who maybe wasn't insane would run, not walk away as she did. She was caught by police as they arrived. It took police 2 to 3 minutes to get there. She did not make it very far because she's not running. She still had the knife in her hand. And when police saw her and told her to put the knife down, she does toss it kind of in this rock area, this landscaped rocky area. She just kind of tosses it forward. So how does that play into a rational person or a sane versus an insane person?
Right. And this is very particular to this case, which is peculiar actually, because normally that would 100% be evidence of this person did not know right from wrong. I mean, they're not trying to run and not be caught. They're walking away calmly. Clearly, it didn't sink in what they had just done. However, for this case in particular, you have this history of the defendant seeking help through trying to have police arrest her. So the reason I mentioned it could cut one of both ways is because if you're the prosecution, you're going to say, well, this is what she wanted. She uh, purposefully planned to commit an egregious crime so that she could be arrested and get the help she needs. I'm sure that's will be the prosecution story, and the defense will be the other way around. And again, as a juror, this is just so devastatingly heartbreaking, that the testimony from the mother, for instance, it did not invoke anger in me. It just invoked more sadness. And so it's almost mentally, can you even get there? Um, to think this was so calm and calculated. And then on the flip side, then you have the sadness of this person seeking help in this way. And it brings to my mind a failure in the system, right? I mean, this being kind of the third attempt at this. So these jurors are going to have a very tough decision. Um, I'm assuming it will come down. I would be very surprised with a not guilty on all of the counts, but there are going to be some very heavy things that will have to be weighed and deliberated when they get back in that jury room.
Let's talk about the deliberation. For those of you who are joining us, we are roughly about 10, 12, 15 minutes away from closing arguments. We're going to try and fill that time to make sure we bring it to you live. I can show you inside the courtroom. It is quiet as we wait. We see Prosecutor Faralia there at her table, clearly preparing for what is a major closing argument. She is one of the veteran prosecutors with the Cuyahoga County Sheriff's Department. The gravity of this situation is clearly not lost on her. Let's talk about the jury and the decisions they have to make. And you brought that up. You said at least you would be surprised if it was not guilty on all the charges. How does it work with an insanity plea? That can the jury decide, well, I mean, she's facing murder and attempted murder. Can she be not guilty on some charges and guilty on others? Because from where I'm standing, and you're the legal expert, I'm not. If I'm on that jury, you have to decide, was she sane or not? And then, you're either guilty or not guilty on all of the charges. Because if you're not guilty because you were insane, how can you be guilty for some of the charges but not the other? Do you understand what I'm asking there?
I absolutely do, and you're right, because all of these charges, this is an affirmative defense, right? Meaning they admit that she did the killing, And the defense now has to prove by a preponderance of the evidence that she was not guilty by reason of insanity. And so it does turn on that one question of, did she know right from wrong at the time? And you're right, Dan. All of the charges, except I think there's a theft charge, but all of the murder charges are going to turn on that one question. So technically, no, the jury should not be able to come back and have guilty for one, not guilty for another. Again, because this is so just emotionally illogical, bizarre, and devastating, I wouldn't be surprised if something messy like that did occur. And that's where Judge Russo would step in at the end to determine if those instructions were followed correctly to the letter.
And when we go into jury deliberations, talk to us about what can happen here. If there is one person in that room that says, I think she was clearly insane, and you just can't convince me otherwise, all the rest of the jurors could say, no, she wasn't insane. This was a ploy. She wanted to get caught. She wanted to get locked up so she could get some help, which again is a problem with the system, as you brought up. What happens if one person just says, you're not going to convince me that she wasn't insane?
Yeah, in Ohio, to be criminally convicted, it must be by a unanimous jury. So it only takes one. The defense only has to truly convince one person, and you can be in a situation of a hung jury, which could ultimately be a mistrial.
What happens if they come back? It's a hung jury. They deliberate, let's say, for 2-3 days, and they just come back to the judge and says, we can't get it to be unanimous. What happens?
Yeah, if there's a declared mistrial, it won't be by prejudice. So there will still be the opportunity for the prosecution to bring this case again if they would like. So that would be in prosecutorial discretion to determine if they would want to retry this again in the event of a mistrial.
And that sounds painful when you think about Margot Wood, that she may have to come back into the courtroom. She may have to tell that story all over again to another jury. I'm just asking you to hypothesize here. As a prosecutor, don't you have to decide, are we really going to put the family through this all over again with a whole new trial?
Painful on all accounts. I mean, I'm sure the jurors are probably going to be impacted by this. All of the attorneys involved are going to be impacted by this case. So absolutely, if I'm a prosecutor, I think they are going to talk with the mother. And I do think they would consider her wishes in that decision of whether or not to retry. Because again, it's what is justice, right? The mother is the one truly who has harmed her and lost her poor baby. So I think that would carry a lot of weight when they have that discretion, whether or not in the event there would be a mistrial. And so I think they would definitely go to her on that one.
So then walk me through, people are curious, what happens to Bianca Ellis? Let's say it's a hung jury, it's a mistrial. The prosecution talks to the mother and she just can't do it again and says, I just want this to be over. Let's say they decide not to try her again. What happens to Bianca Ellis at that point?
I think this is an instance where there would have to be some type of plea agreement that would come into place. Um, I think it is obvious just on the face of all of this that this person needs help and clearly cannot be simply put back into society. And I think her defense counsel knows that. And so while the prosecution would have the leverage of bringing another trial, right? I could see both sides coming together and figuring out what can we do here to get this person put where they need to be, to get the help that they need without putting this mother through the pain of another trial.
Yeah, and that's something that's going to have to be considered. Okay, let's take a step back. Let's say the jury comes out with a not guilty by reason of insanity verdict down the board, what happens to Bianca Ellis? Does she just get to walk free?
I'm not sure of all of the particulars in the case to know if there would be. I'm assuming and I hope we could at least do, if even if it's like the civil commitment into psychiatry. So I'm not sure. I haven't followed where kind of defense is on that. If there's been any kind of thing publicly known to see what they're thinking of that. But again, I can't see, with all of the responsible parties being at play here, that happens. And I know my job is to legally, how can it not happen, right? But just on the face of things, I can't see it happening. And I will also say Judge Russo is one of the best judges we have. And if that were the case, I wouldn't be surprised if he were able to kind of just intervene with the parties in some way. Obviously, to the extent that it is and would be appropriate to figure something out here.
Yeah, because a lot of people have been talking about that. We hear from viewers saying, if this woman is allowed to go back out on the street, that's what people are afraid of. And I don't think we have heard a scenario at all through all of this where that could happen. Even if she is found not guilty by reason of insanity, there is a large belief that, as you said, she would need to be committed somewhere and given treatment and follow the process that way.
Yeah, and again, not based on the outcome of this particular trial, but just simply looking at all of the parties involved and just socially, logically, I would think these responsible attorneys, the parties involved will figure something out. But again, legally, on the basis of this trial, you're not guilty is not guilty. But I just don't see, it, just in my personal opinion.
Yeah, no, I totally agree in there, and that's kind of what we have heard across the board, that something will have to happen to try and get this woman the help she needs, regardless, whether she goes to prison or whether she is found not guilty. There needs to be some help. Tara, let's talk about deliberations. And this is the question reporters like to ask defense analysts all the time when it comes to the jury. Will this be a short deliberation, or will this be a lengthy deliberation? Or could it be somewhere in the middle, obviously?
Maybe somewhere in the middle. It's certainly going to be on the shorter end, just because it really only comes down to one question that they have to consider. So when you have trials where you do have to go through the jury instructions to discern various different elements, and did they prove this element beyond a reasonable doubt? Did they prove this one beyond a reasonable doubt? Really, all they have to consider is, did the defense prove beyond a preponderance of the evidence that she did not know by reason of her mental illness right from wrong at the time? And so it should be on the shorter end, surely just because of the logistics of, they don't have a ton that they have to really go through.
And again, to be a fly on the wall in the jury deliberation room, and I apologize, I don't know the makeup of the jury. I'm going to show another live look inside the courtroom as we are getting closer. Perhaps within the next 5 minutes, we should see the judge and the jury come back in, and this will be our closing arguments for both sides. Tara, I'm going to have you hang out with us for just a couple more minutes. As we get closer to the closing arguments, I want to show our viewers a story from our Colton Molesky. I think did a great job yesterday encapsulating sort of where we are with this trial over the first, technically it was the first week, and where we were in all of this. I think this will really sort of paint the picture for a lot of people heading into closing arguments. Take a look.
I saw her coming, walking towards us, and I noticed she had a knife in her hand. And I said, "Oh no, Julian."
The heart-wrenching testimony of a mother's final, fear-filled moments with her son in a Giant Eagle parking lot before he was taken in a brutal attack.
She just walked away. Like nothing. She just walked away.
From the beginning, there is one fact neither the prosecution nor defense dispute. It's what would normally be the key difference in any other trial.
She's responsible for the murder of Julian. She acknowledges to her lawyers that she's responsible for the attempted murder of Margot. There's no running away from that.
The state spent days going through hours of security video and calling 20 witnesses, their testimonies, painting a picture of what happened in June of 2024, leading up to and during the ruthless attack on Margot and Julian Wood.
So when I pulled up next to her, I asked her, I said, "Do you know you stabbed that kid?" And her response was just a shrug of the shoulders.
The defense called just 2 witnesses, doctors, trying to prove Ellis was insane at the time of the attack, someone with schizophrenia and a history of mental illness, battling things out of her control.
And was experiencing symptoms at that time related to this illness that caused her to not know what she was doing was wrong.
The state had a doctor of its own, a rebuttal witness directly challenging those claims.
However, that the defendant did not have a severe mental disease or defect at the time of the June 3rd, 2024 offense that caused her to not know the wrongfulness of the offenses.
In Cleveland, Colt Molesky, 19 News.
And again, we bring Tara Coleman back in, our defense analyst, as the closing moments of the lunch break are upon us. Tara, anything stick out to you when we sort of look at the whole encompassing story? I can't tell you the number of conversations I've had with people who say, how can you not notice somebody walking and swinging their arm with a knife in it? You saw all those people who walked right by Bianca Ellis, didn't stop, didn't panic, didn't yell for somebody to call 911. The video, there is so much surveillance video of her walking with this knife in plain sight is just really tough to take.
It is. Honestly, it does not surprise me that much when you think of how just as a society, we genuinely are in our own heads a lot of the times. We're in our phones. We're ruminating over whatever our personal lives are going through. And I do think we have a lack of not being present and in the moment a lot of times. It seems so obvious, but I'm not entirely surprised.
It's a conversation we've had in our newsroom when we first saw the video come out from the incident, now more than a year ago. We all had the conversation, and half the room said, I would notice right away if I saw somebody with a knife in the hand. There's the other train of thought that when you go to the grocery store, you've got your blinders on. I want to get my milk, my eggs, my bread. I want to get to the register. I want to get to my car, and I want to get out of there. So how much are you truly paying attention to the other people around you? And the defense tried to use that. There's this idea of concealing the weapon. Would a sane person, and again, forgive me for having to use these terms, but would a sane person walk around with the murder weapon for the murder they're about to commit? Or is that the mark of an insane person? How does that play into the jury?
Absolutely. That is definitely a point that they will have to weigh, because it is evidence and it does indicate, okay, this person does not know right from wrong because they are not trying to conceal any of this. On the other hand, just because of the nuance of this case, it just so happens that there's a flip side of she wanted to get caught doing something. That's what's so tricky about this, because you have on one side what is normally such insane behavior. The prosecution almost has a motive for it, which is just so strange and just particular to this case.
Tara, what should our viewers look for? I'm going to show the courtroom again. We're getting closer. We're starting to see some of the attorneys and the court staff come back into the room. The break is supposed to be over in 5 seconds, putting us right at 1:35. But what should our viewers look for here? Is there something that will get said by either the prosecution or the defense that could surprise us, could show us that somebody feels strong about their case. If somebody goes short, are they confident? If somebody goes long in their closing arguments, are they not very confident?
Yeah, so what we're going to see, obviously, judge will come back in, everyone will rise. I'm assuming we're not showing the jury, so they will come in off camera. And Judge Russo will go over the parameters of the closing arguments. These attorneys they definitely have their closing statements drafted already. Barring something that happened this morning that was surprising, I don't see that changing much. And so I say that to say, short or long, it is going to be what it's going to be. And I think both sides definitely will take the time to get out what they need to get out. What I would be looking for, just if I'm watching this, I'm looking for any inconsistencies in the closing argument from the opening statement or argument. What happened in the course of this trial that attorney believes changed between the opening and the closing? So that's what I'm looking out for, any inconsistencies there.
That makes sense. I'm watching some of the attorneys in the courtroom. I have seen both the prosecution and the defense use USB sticks, so clearly there's going to be more showing of the evidence. And looking at the defense, I'm going to guess that he is going to play a lot of the walking around with the knife video. As I say that, I want to warn our viewers that in all of the video that we have shown of Margot and Julian, it is edited. We have blurred both Margot and Julian while they're in the shopping cart as they're leaving. That is not the way the video has been shown in the courtroom. That is not up to us. It is up to the defense, but they have not blurred out Julian. Now, the attack itself that occurs in the parking lot, there is a camera on top of Giant Eagle, and the attack happens roughly 100 yards away. It's not super clear, but I do want to warn our viewers that it is possible they show the attack again. There is nothing easy about this case at all. And so we will warn our viewers with this. Tara, as we get closer and we can see Defense Attorney Mack now coming back into the room, as a defense attorney with something of this magnitude riding on the jury, as a defense attorney, are you nervous? What has to happen here with your closing argument? Your client's life is on the line.
You're not nervous at this point. When you feel confident that you have done everything you can do for your client, when you feel confident in your preparation and how you performed at that trial, closing arguments is where you bring it home. It's not the time for anxiety or nervousness, and a good defense attorney is going to be able to function under that high pressure and deliver. Again, back to your questions of what to be looking out for here. What is key is, did the defense attorney or did the prosecution say in opening that they were going to prove or show something that they have not proven or shown? And if you tick through everything you referenced in that opening and say, see, I told you I would show you this, I told you I would show you that, and then you explain how you did those things, that's the person that's confident in how the trial is going to come out. You're not so confident in closing if you gloss over maybe something you said in opening that you were going to show or highlight and you don't bring it back up. That's when you're not so confident. That's what you're going to be looking for.
Tara Coleman, defense attorney here in Cleveland, one of our legal analysts that helps us so often. It is truly appreciative to have your expertise and your knowledge in this difficult case, and I'm sure you'll be watching closings right along with us. I want to thank you for joining us this afternoon. We appreciate it.
Yeah, thank you, Dan.
All right, take care. Again, a live look at the courtroom where we are more than likely just seconds away from getting back underway. I'm not entirely sure as to the reason for the delay here, but it will be getting resumed here shortly. What we can do is I'm going to play again for you, though there might be some of you just joining us. And in fact, I'm going to talk to our digital staff here. If we want to send the push alert that closings are about to begin, we can do that to bring in that audience. But as we wait for that, I want to replay for you the story from yesterday from Colt Molesky that I think does such a great job of really tying up what this case is about as we get into closing arguments, because it's really going to be the crux of what we hear coming up. Again, we're running a couple of minutes behind here. We expect the judge in momentarily. We're not going to miss a single second of closing arguments. And then this case will be handed over to the jury. As we heard from Tara Coleman, she expects closing arguments to be approximately 20 minutes for both sides. And then the prosecution, the state, will get maybe another 5 minutes for a final word to be able to rebut anything the defense says. But let's, as we wait for this to begin, let's remind our viewers how we got here. It was a beautiful June day in the summer of last year in 2024. A mother taking her son to the grocery store to get something for dinner. Little did she know the pain and terror that was headed her way, simply checking out of the Giant Eagle in North Olmsted with her groceries, and she had no idea what was about to happen that would change her and her family's life forever. Let's do just a quick review as we wait for the judge of how we got here to this point in the trial.
I saw her coming, walking towards us, and I noticed she had a knife in her hand. And I said, "Oh no, Julian."
The heart-wrenching testimony of a mother's final, fear-filled moments with her son in a Giant Eagle parking lot before he was taken in a brutal attack.
She just walked away. Like nothing. She just walked away.
From the beginning, there is one fact neither the prosecution nor defense dispute. It's what would normally be the key difference in any other trial.
She's responsible for the murder of Julian. She acknowledges through her lawyers that she's responsible for the attempted murder of Margot. There's no running away from that.
The state spent days going through hours of security video and calling 20 witnesses, their testimonies, painting a picture of what happened in June of 2024, leading up to and during the ruthless attack on Margot and Julian Wood.
So when I pulled up next to her, I asked her, I said, "Do you know you stabbed that kid?" And her response was just a shrug of the shoulders.
The defense called just 2 witnesses, doctors, trying to prove Ellis was insane at the time of the attack, someone with schizophrenia and a history of mental illness, battling things out of her control.
And was experiencing symptoms at that time related to this illness that caused her to not know what she was doing was wrong.
The state had a doctor of its own, a rebuttal witness directly challenging those claims.
However, that the defendant did not have a severe mental disease or defect at the time of the June 3rd, 2024 offense that caused her to not know the wrongfulness of the offenses.
In Cleveland, Colt Molesky, 19 News.
And again, a live look inside the courtroom as we wait for closing arguments. Take a closer look as we see the attorneys for both sides putting their final touches on their closing arguments. Just going to take a listen into the courtroom. Looks like the administrator is asking some instruction questions. What will happen first is Bianca Ellis will be that deputy who's standing by the door there He will bring Bianca Ellis out. There will be an all rise for the judge. The judge will come out. He will then give the all rise for the jury to come back into the courtroom for this final stage. This is technically day 6 of the Bianca Ellis trial. And again, and I think we will hear this multiple times in closing, this is not a question of whether or not Bianca Ellis is guilty of murder, or at least not a question if she carried out the murder of little 3-year-old Julian Wood. This is a question of whether or not Bianca Ellis was insane at the time of this incident. As we heard from our defense attorney, we're not talking about insane in the 10 minutes before, in the 5 minutes before. Was she insane when she carried out the attack? Her attorneys are saying there is no doubt that she did this. She has taken responsibility for the murder of little Julian Wood and the attempted murder of Margot Wood, his mother. But the question is, what was her mental status? And we heard from a number of experts, both on the state side and the defense side, that said she has suffered from mental illness, including schizophrenia, for the last at least 10 years. And we do know from testimony that she had been off her medication for at least a year. There was one surprise to us in this case when the defense got up and made their opening arguments. They made comments to the fact that Bianca Ellis's own mother, that the jury would hear from Bianca Ellis's mother that she is a different person when she's not on her meds. Now, generally, when you make a statement like that in opening arguments, that means that her mother would have taken the stand at some point to be a witness for her. We did not see that. Now, was that just phrasing? Was that paraphrasing? Because we did hear from police that testified that they talked to Bianca Ellis's mother the day after the attack. Or did the defense decide it was too risky to put her mother on the stand? Because if you put her mom on the stand, the prosecution then gets their chance to grill her with any and all questions. It could have been just too risky for the defense, or that the mother didn't have that much of a perspective to give. That would have been clearly the right of the defense to call her up there. Again, we're running now about 15 minutes behind as we wait for the judge, Bianca Ellis, and the jury to get closing arguments. And every minute that goes by makes you wonder if they will do closing arguments and dismiss the jury for the day. And there is Judge Russo. There is a brief little bit of an all rise, and then seated. Judge Russo, not a particular stickler for the ceremonial part of the all rises when it comes to his entrance. Now he is when it comes to the jury. He is very insistent that everyone rise for the jury. That has been pretty consistent. The judge is going to take his seat on the bench. I expect we will see Bianca Ellis, although it looks like he is going to have a sidebar here with both the defense and the prosecution. This is probably just in regards to how he would like to see these closing arguments play out. There could be a time limit being discussed, discussion of what's going to be shown, what isn't going to be shown. And think about the jury and everything they have already had to sit through. The autopsy portion of this case was particularly tough to sit through, hearing about the damage that 12-inch butcher knife did to Julian, to such a small child, just 3 years old at the time. as we get closer to closing arguments. There were pictures that were incredibly tough to see, and as we heard from Tara Coleman, our defense attorney, that is the kind of thing that is going to stick, with a jury, and that's what they have had to deal with through this process. Again, just waiting for closing arguments. A lot of this video that you see right there, that was video from many of the pre-trial hearings for Bianca Ellis when they were trying to get her to be restored to competency. That's something we didn't talk a lot about in the immediate weeks and months after the attack. It was determined that she was not competent to stand trial, and that has a number of its own legal definitions, meaning she was not of the right frame of mind to understand the process, the court process. But they sent her to the North Coast Behavioral Health Center. That is in the Sagamore Hills, Northfield area. She was originally placed there and refused to take medication. Then they had to have another pre-trial hearing to where the judge ordered forced treatment, to where the hospital had to force her to take medication. That process played out for a number of months, and then it was determined that she was finally restored to competency so that she could stand trial and help in her own defense. That is the determination that they make. Is this person of the right mind that they can help their defense attorneys navigate what happened and their state of mind at the time. The judge continues his sidebar here as we await, and it looks like they're potentially wrapping up. But again, these are probably just final instructions for what has to play out here for closing arguments. The amount of time each side will get, a rebuttal by the prosecution before the case is given to the jury. And I go back to, I keep looking at the clock, so we're clearly at about 2 o'clock here. If, let's say, closing arguments takes 20 minutes each, 40 minutes, a final rebuttal, perhaps closings will take an hour. That would put us at 3 o'clock, and the question will be, I want to see where the judge is headed. Oh, the judge is just making sure the microphones are on. He can control part of the volume on the microphones, but it'll be interesting if the jury is given this case at 3 o'clock. Will he have the jury deliberate for an hour, maybe an hour and a half, or will he send them home at the end of the closing arguments? And there we see Bianca Ellis receiving final instructions from her attorneys, probably explaining the process, what to do, what not to do, as far as reaction when we get to this. And now we're just waiting for the judges all rise for the jury. And again, as you are watching this, I want you to put yourself in the shoes of the jury. And I want you to listen to both the prosecution and the defense's arguments. Where would you land as a juror? Do you think she was insane at the moment she committed the act? There is no question. Both sides agree that she was mentally disturbed.
I think we can all agree that it's tragic circumstances that have brought us together. But as Ms. Faralia told you at the outset of her opening statement, it is a privilege to present this case to you on behalf of the state of Ohio. And before you get to deliberate on this matter, I will provide my closing argument. Then you'll hear from Mr. Mack and Mr. Johnson, and then you'll hear once again from Ms. Faralia, because the state of Ohio bears the burden, and you'll hear from the state last before you deliberate. Ladies and gentlemen, we are all together today because of the choices Bianca Ellis made on June 3rd of 2024. That day was like any other day in the life of Margot Wood. And I think we can all relate to what she did that day. Take your kid to the grocery store. It's something that is fun. It's a little get out of the house, buy candy, flowers with your child. And yet, that ordinary act turned into an unfathomable nightmare because of what this defendant chose to do on that day. So what I'm going to do is I'm going to walk us through the indictment, the charges that we have charged Bianca Ellis with, and then we're going to shift our conversation to the affirmative defense that she has raised. All right? So I want to start with count 1, which is aggravated murder. That Bianca did purposely and with prior calculation and design cause the death of Julian Wood. And under Ohio law, the key terms here are prior calculation and design. All right? Those are the words you want to pay attention to when you're deliberating on count 1. What does prior calculation and design mean? Well, you'll have those instructions with you when you deliberate. And in part it says, it's the process of reasoning that must have included a mental plan involving studied consideration of the method and the means, or the instrument with which to cause the death of another. The amount of time that the defendant spends in planning isn't really as critical, but she needs sufficient time and opportunity for the planning of the homicide. So did Bianca Ellis give thought or preparation to choosing the murder weapon in this case? Yeah, she absolutely did. And we can all see it in State's Exhibit 192. And you'll have this, 193. 182, Your Honor, I apologize. Sure. Ladies and gentlemen, you will have these videos back with you when you deliberate. I'm going to let this play for just a second, and then we're going to be quiet. I'm going to be quiet for about 50 seconds while we watch Bianca Ellis choose her weapon. "50 seconds. We watch that defendant go directly to the houseware aisles in Volunteers of America, go through that bin, look at the knives, inspect them, handle them, look up top of the knife block up there. She spends almost a minute looking through these knives. She doesn't pick the first one she sees. She finds the 2 favorites of hers, and then she walks out of the store. She made a decision. That was careful. We spent a lot of time on cross-examination with Dr. Knopfsinger today about how Bianca Ellis didn't just stab anyone in the Volunteers of America store. No, and that supports our argument. This was calculated. She walked out of that store and went to the store next door, encounters more people on her path. And then when she gets to Giant Eagle, that's when she chooses her victim. But she knew when she chose those knives what she was going to do. She was going to harm someone. She was going to take somebody's life. Now, murder is count 2 and 3, and they're charged under different sections. So count 2 is that Bianca Ellis did purposely cause the death of Julian Wood. And count 3 is that she caused his death as a proximate result of an underlying felony. And what we mean by that is that he died because she committed or attempted to commit felonious assault and or endangering children. And with these charges, there are degrees of culpability and mental states. Okay, so when we're talking about purposely, and again, you'll have all this in your instructions, but these are the definitions of purposely and knowingly. And we're talking about this defendant knowing that her actions would bring about a certain result. Okay, so we know that when she selects that butcher knife and she ultimately stabs 2 people with it, that she's going to bring about a result, right? She's going to hurt them. She's going to kill one of them. And you think about it, with a butcher knife, if you stab somebody, that's going to be the result. You harm or kill. Okay, so when you deliberate these counts, ladies and gentlemen, you can consult your instructions. I'm not going to go through these ad nauseum, okay? I know that you are a smart, attentive jury, but I do want you to pay close attention to count 1 and talk a lot about that prior calculation and design and the plan that Bianca Ellis had that day. And of course, she had no relationship to these people, and that's okay for proving prior calculation and design. You want to focus on the time and the consideration that she spent choosing her weapon and the steps she took after that. Now, we're going to go through the timeline. We have the benefit of really having all of these actions captured on video. So we know that in a couple days prior to June 3rd, Bianca Ellis had a run-in with the North Olmsted Police Department. And that's important because it's part of the anger that fuels her on June 3rd. You heard testimony about how she was in their jail for a night and that she was purported to have all sorts of property and money and gift cards and other items. So when she's walking around on June 3rd, we know that that's on her mind. She says as much herself. But let's walk through this timeline that we have, right? And again, you're going to have these videos. You'll have the compilation video that we went through together. But what I put together today is a kind of a streamlined timeline, all right? So we can see kind of minute by minute where she is. So at 2:36, you see her in that yellow circle. She's in her wheelchair. She's on the North Olmsted Police Department property. A couple minutes later, here she comes into the lobby, and you meet Danielle Shook, one of the first witnesses you heard in this trial. And if you remember how their encounter went, Bianca Ellis wasn't so happy when she left the lobby. Remember, she turned the lights off as she departed the lobby. And then she kind of skips down the stairs. She ditches her wheelchair and her suitcase. And you can look at the video again, of course. You heard testimony that she walked with purpose and that she was angry. You can watch that video again that we watched here this afternoon. The careful selection of the weapons, minute by minute here. 14:55, so 2:55, less than 20 minutes after she went to the police station, she's got her weapon. $14:56, she's going to enter the Things outlet. She walks in, looks around. Pay attention. She's got 2 knives still behind her back, and she's looking around. Ladies and gentlemen, she's looking for a victim. These people, they're adults. There's men in the store. Those aren't suitable victims for Bianca Ellis. She's got to find the most helpless victim she can to carry out her crime. She exits. What does she do then? Well, she's got 2 knives. She can't use 2 knives. So she's got to ditch one. She's got to keep the best one. What does she do? She taps her knives against the brick column, ditches the flimsy one, keeps the superior knife to carry out her act. Look at her walk. She's not going into that store for anything but to wreak havoc on somebody that she hasn't chosen yet. And unfortunately, or fortunately, how you want to frame it, again, it's all on video, what she does that day. 2:57, there she is, knife in hand. Again, this is 22 minutes have passed since she went to North Olmsted for her money. And here it is. Ladies and gentlemen, this is the decision she makes after she's selected her weapon. These are the people she wants to harm. It's been decided. This is a volitional choice, ladies and gentlemen. This woman is not experiencing, and we'll get there, but this is a woman who has made decision after decision and planned this out. And finally, at 3 o'clock, we know what happens. Now, part of my job here is to make sure that you understand the elements. I'm not going to dwell on this at all, but we know that a child died. To prove that there was a death in this case, we had to show some autopsy photos. All right, I'm not even going to enlarge them on the screen here. You can see these 2 photographs. We know that we have a deceased victim. We also know that Margot Wood was stabbed and that she was injured, okay, for the attempted murder charges and the felonious assault. She has scarring on her body, and she will always have that scarring. So the state has met its burden as to those counts as well. This case is unique, of course, as we all know, that the burden shifts, right? The state has proved beyond a reasonable doubt all these elements of all the charges against this defendant. Now, there's another step, and you all know it, and we don't have to overthink it. I know it is complex, but at the same time, we want to take it step by step and not overthink what we have to do. So what does it mean that she raised this defense? Well, you know that she has to prove something to you. Has she done that? And how can we tell? Again, I'm not going to read all this stuff. I usually don't put much writing on these slides, but because there is so much to get through, I want you to be prepared for what you'll have to read and talk about in your deliberations. The testimony from Dr. Knopfsinger is pretty fresh in all our minds because he finished his testimony today. The fact that this defendant has schizophrenia does not excuse her for her conduct. So now we are talking about kind of the battle of the experts. Let's talk about Sarah West. All right, you heard from her last week. Her opinions are based almost solely off of this defendant's self-reports. I don't know about you, but I got the sense from her testimony that she either hadn't watched the videos or really did not remember them and did not factor into her analysis of this defendant. You'll have her report to go through. When she was asked about basic things about these videos, she did not seem familiar with them whatsoever. And you've heard from Dr. Knopfsinger how crucial these videos are. This timeline, the methods that this defendant goes through to make her decisions, Dr. West seems to not put much weight in that at all. So that's what I mean by she does not use corroborative evidence from June 3rd. But she agrees with us that June 3rd is the day we're going to focus on. We're not really talking about too much that happened before. We're going to talk a little bit about afterwards, but really June 3rd is what we are really focusing on. Something that struck me about her testimony was that Dr. West said, "I see a lot of psychosis here." And I didn't really know what she meant by that because, again, she didn't use corroborative evidence. Not one witness in this trial testified that Bianca Ellis was talking to herself or muttering things, talking to anybody. So Dr. West's suggestion that she was hearing voices didn't make a whole lot of sense to me. And we talked a lot about anger and rage, and that is really the crux of Dr. Knopfsinger's report. And we know that Bianca Ellis was not medicated on June 3rd, but we believe she was very angry, and that motivated her to commit these crimes. But Sarah West doesn't talk about anger. She kind of agrees with us eventually that anger could cause someone to commit a crime. But again, she is not focusing on anything but old medical records and the defendant's responses. Do you remember Dr. West talking about disorganization? That was a big theme of her report and her presentation. And she didn't really define it. And she also said things like, "I believe," and "maybe so," and "probably." Ladies and gentlemen, the preponderance of the evidence is a different burden than the state has to prove when we are proving the elements against this defendant. Think of the tipping of the scales, okay? It doesn't have to be much of a tip. If you don't believe Sarah West, the defendant has not met her burden in this case. And I submit to you that she has not met that burden. Her theme doesn't make a whole lot of sense. She kept saying that this defendant was disorganized. And I did not find that to be helpful because she didn't really explain it, but Dr. Knopfsinger does. What does he say in his 36-page report where he overturns every video, every record, every interview, and he analyzes it through his expert lens? And again, you can see his report, you can read every word. He talks about what disorganization means. It is word salad. It is gibberish. It's nonsensical. His examples that illustrated this were someone that is loitering or trespassing, doesn't understand what they're really doing. They're kind of aimless. Bianca Ellis isn't aimless, she's angry. She's not disorganized. She's committing a specific willful act. She is not a disorganized person. And Knopfsinger really delves into that for us. So here we are. There's two prongs, as you know. I know you paid good attention in this case. And it's the second prong that we are really focusing on. There is no question this defendant is schizophrenic. That's prong one. Bianca Ellis suffers from a severe mental disease of schizophrenia. However, the fact that she has that diagnosis does not mean that she didn't know what she did was wrong on June 3rd. Pay attention to her interview with Dr. Knopfsinger. Okay? She's not being paranoid. I thought some of the best testimony that made sense to me was about, oh, she's not talking about, you know, there's aliens or there's ghosts or whatever there is that I'm protecting these people from. There's no delusion. There's no grandiose explanation for what she did. She doesn't think that these people are harming her. Those were examples Knopfsinger used to explain why someone might act the way she did if they truly were insane at the time of that act. We have none of that here. None of that. She is fueled by anger. She is dehydrated. These are her words. You'll watch the video. She's dehydrated. She's hungry. She hasn't slept. It became a perfect storm. Keep in mind, Dr. Knopfsinger has testified for the defense and the state. There's 30 plus years of being a psychiatrist. He has seen a lot of different things come across his desk. He has no interest in the outcome of this case beyond the work that he did, the report he made. He's telling us what is based on his experience, his training, his knowledge. This is not an NGRI defendant, and here's why. Today, he told us that in order to be successful on this affirmative defense, she's got to prove that what she thought, what she did, was right. And she has not explained that in any way. There is no rational motive. I'm sorry, the rational motive that she provides is what we need to focus on. Hungry, dehydrated, missing money. It all comes together. And when she's angry and she sees those people, the relationship, the close relationship in time, that's what we have. That's why we're here. So, ladies and gentlemen, you'll have all the evidence. You can go through all of it. I know there's a lot. There's body cam and there's interviews. Watch her interview the next day. I want you to do that because she's still very angry the next morning. And I remember when we played the interview in court, how loud it got towards the end. You could hardly hear her in the beginning, and then later on, she's shouting, "Stupid people, liars, thieves." And again, the way she acts directly after this, Dr. Knopfsinger pointed it out, and I think the other witnesses explained it as well. She is not saying, "No, don't arrest me. I didn't do anything." She doesn't run away. But she does walk away calmly. She doesn't stay on scene at the car. She succumbs to the officer commands. She never protests her arrest. And Knopfsinger tells us that these are behavioral factors that indicate that she knew she did something wrong. The actions of stabbing. What a personal, gruesome thing to do. And I think on cross-examination, Mr. Johnson talked about, well, wouldn't 30 stab wounds be more indicative of rage? No. Ladies and gentlemen, stabbing anybody with anything is an act that would be fueled by anger. To have a 10-inch knife with a 7-inch blade and to select the most helpless victim possible and then stab that victim twice, that is rage. That's what we have in this case. All right, so here we are at the very end, kind of to recap our timeline. She's upset. She goes directly to the knife houseware aisle in Volunteers of America, and she carries out her crime. Ladies and gentlemen, I urge you to go through all of the evidence together. I know that within your collective memories, the 12 of you, some of you may have taken lots of notes, some may have not taken many notes at all, and that's all right. Listen to one another, talk to one another. Go through every video, the reports by the doctors, and discuss. Think but don't overthink. Bianca Ellis is responsible for the death of Julian Wood. And Mr. Mack told you that, if you remember, in his opening statement a week ago. But she did it with prior calculation and design. She knew what she was doing that June afternoon. Hold her accountable for what she did to that child and his mother. She knew what she did was wrong. Find her guilty. Thank you.
Thank you, Mr. Taylor. Mr. Mack, Mr. Johnson?
Please the court, State of Ohio, members of the jury, good afternoon again. When I first learned of this incident, I learned through the media like a number of you, and I said to myself, what crazy person would kill a 3-year-old child? Those were my words. I said, this world is going to hell. And as fate would have it, I get assigned to the case. And then I began learning about this woman right here. I came to understand that there was mental illness. I came to understand how this came to be. The elephant in the room is this. You have a 3-year-old child whose life was taken from him. Not by his fault, not by his mother's fault. Bianca caused the death of that child. And we all know that this family doesn't deserve this. I implore you to embrace your humanity. It's okay to feel the pain that they're going through. If watching life-saving measures, trying to save a kid's life, if listening to a mother asking if her child is alive doesn't move you, then I question your humanity. If seeing photos of a deceased child, listening to a parent's pain, listening to a mother having to leave out of this courtroom, if that doesn't move you, then I don't know what could. Again, I question your humanity. Knowing that the bail can't be unmarked. Because I know a lot of lawyers will tell you, you got to set this aside. You can't set that aside. But guess what? You have an oath. And no matter how much courage it takes or how challenging this is for you, you said during jury selection that you would follow that oath. Now, Mr. Johnson and I, we have to concede that this case emotionally is difficult. I watched you cry during this case. I've been practicing for 31 years. This is one of 3 cases where I felt as you did. That's okay. But you also made a pledge that when you make a decision in this case, it will not be based on sympathy. And you can feel the emotions that you must have experienced during this trial, but still make the correct decision. So when Ms. Patel tells you that Mr. Mack said in his opening statement that Bianca's responsible, that's true. Even though it's not evidence, that's true. Now I'm telling you in my closing argument that she is responsible for the death of Julian, and you should find her guilty of murder, keeping in mind not guilty by reason of insanity, being a defense, and you should find her guilty of the felonious assault as it relates to Margot and a number of the other charges. The aggravated murder and the attempted murder, I'll talk about that later. Look, when this case began, Bianca had options. She could either plead not guilty, she could plead guilty, or she could plead not guilty by reason of insanity. By now you know what she chose. Your job is not to focus on penalty, no matter which side you come down with respect to this. The state's strategy in this case has really been to normalize Bianca. They make the acknowledgement, and they have to concede because they can't get around it, that she's mentally ill. But they want to normalize her behavior on that day. She was in control. She was well organized. Her mind was working separate and apart from her schizophrenia. There was nothing normal about Bianca Ellis on June 3rd. There's nothing normal about her behavior. I want you to look at Bianca Ellis. 1 week from the date of the incident. She's at her arraignment. She's smiling at her arraignment. Even though it's been put forth to her that she could possibly receive the death penalty. Who smiles? Who does that 1 week after this incident? Not someone normal, but guess what? More than a year later, she's medicated now. This is what you've seen throughout the course of the trial. Take a look at it. When someone's medicated, they're confined, their schizophrenia isn't active, they're not hallucinating. Those are 2 different people. But even then, 1 week after, weeks after, months after, her mental illness was still active. It hadn't even ceased by the time that June 10th came around at her arraignment. They want to tell you that Bianca has to tell you what exactly she's hearing in her head. Bianca has to give you this theme that they've come up with that's not even in the diagnostic statistical manual. There's no authority for that. You can believe some, none, or all of what a witness says, even if they're an expert. Even if the narrative is trying to logically make sense. Think about it. And the doctor is mistaken, because I won't say the other word, but he's mistaken. Those are his words, well organized. He says that Bianca was well organized when you look at her behavior on June 3rd. He's the one that introduces rage. I couldn't get up and say it, but if you look at that interview, he introduces this concept of rage. Those are his words. She feeds him back what he's discussing. And if someone is well organized on the date of the incident, she rolls up to the police station in a wheelchair. Eventually she pushes that wheelchair. She has some conversation about the money. And then she leaves her wheelchair and her suitcase at the police station. She walks into Volunteers of America. She selects a couple of knives. She walks out. She walks into the next store, Things Outlet, with knives. And then she goes to Giant Eagle. Eventually she sees Margot and Julian, follows them out, and the incident occurs. The state would have you believe that this was all volitional, normal behavior. She goes into Volunteers of America, and she does, in fact, select 2 knives. Their theory is that this is about her anger about what happened at the police station of not getting her money. She walks into an unauthorized area while in Volunteers of America. She always has the knives out in the open. The first person that she has interaction with is the manager at Volunteers of America, an elderly woman. She doesn't stab her. She walks around the store. She stabs no one in Volunteers of America, and she takes a knife and she walks past the cash register. In the open. Both knives. It's not normal behavior. There's something that's going on there. And then she walks into Things Outlet. And the prosecutor would have you believe that, oh, she's hiding knives. If she wanted to hide knives, she could have concealed them underneath her clothing. She has both of her hands on her hips. When you go back there, look at that video. Her hands are on her hips, and she's looking around. Because whatever's happening right here is dictating her behavior. She doesn't see what she's looking for. She comes out, she taps a knife on the pillar, and she loses 1 knife. She walks with the knife in the open, outside. Now, the doctor can talk all he wants about, well, it's a crowded inside of the store. You saw how many cars are out there in the parking lot. Bianca can't predict who's getting in and out of their cars. It's crowded, it's in the middle of the day, it's 3 o'clock. And I know you had to pay attention when she's walking with the knife, when she enters the store, and she walks past what appears to be an elderly gentleman, there's a woman coming. None of those people get stabbed, despite her motive being rage. Only when she sees Margot and Julian does she do this U-turn. Now, I want to pause there for a second. Because I'm not going to pretend like I'm a psychiatrist or a psychologist or any kind of doctor for that matter. But you're allowed to use your collective minds, all 12 of you, to try to figure out, based on the evidence, what was going on there. Why is it that Bianca, if she's so upset about her money, why is it taking her so long to stab somebody? We know it doesn't happen at the Volunteers of America. We know it doesn't happen at Things Outlet. We know that she doesn't go back to the police station and take her anger out on the people that wouldn't give her her money. So what's going on? You're allowed to consider take 2 steps back and ask you, I just really want you to think about this. Does it make sense for Bianca to be angry about money that she didn't receive from the police department, to seek a 3-year-old child out and stab a 3-year-old child because she was feeling that anger and that rage? Commonsensically, does that make sense? We know that immediately following the incident, she walks away. That's what the State of Ohio's witnesses told you. She walks away as if nothing had occurred, like a walk in the park. And she continues to walk with that knife in hand. And the only time that she puts that knife down is when she's confronted by the police. That's not the behavior of someone who's criminal-minded. I haven't handled any cases like that. Someone walking away from the incident and doesn't put the weapon down and they walk away. Whatever's going on in their head, it is still happening at that moment in time. If you were to take Dr. Knopfsinger's opinion at face value, the only way that she could have been psychotic or having this insane moment would have been for her to stab Julian in the store, sit down right there, don't run, make sure you leave the knife because you don't want to leave fingerprints, and then tell the police or whoever else would listen that she had this experience of wanting to kill a child. It's easy for someone that's been practicing medicine for 30 years to get up here and mislead. Because I guarantee you that what he says should have happened, it's not required in the DSM-5. His very authority that he has to rely upon, there's nowhere that says that you are required, if you're mentally ill, to articulate what you're hallucinating. You can believe some, all, or none of what a witness says. And again, I have to be mindful that you are deeply impacted by the fact that a 3-year-old child lost his life. I get that. That's why she's admitted to the murder of Julian, admitted to the felonious assault of Margot. But you just can't brush not guilty by reason of insanity under the rug because it exists in this case. Even at the police station, she's interviewed for a period of 6 to 7 minutes. Keep in mind that she never says a word to anyone other than the manager at Volunteers of America, where she allegedly asked, "Where's the restroom?" But throughout this whole ordeal, she doesn't have a conversation. In that interview, the detective tries to interview her, and her focus is on the money. And eventually she says, "You can put the Giant Eagle investigation into that investigation." That makes no sense. And when she yells attorney, she's not talking about the Giant Eagle situation. Please watch that interview. She's talking about the money situation. You got to keep in mind that this woman was in jail May 29th. And there's an officer that identified the fact that she's not mentally well. It's just a couple days before this incident. The state has made a concession that there's severe mental disease. They acknowledge that there's schizophrenia. You heard from Dr. Tesla, you heard from Dr. West, that even when they interviewed her, a month later, her psychosis is still active. She's still mentally ill. She's still disorganized, and Dr. West does explain disorganization. Whatever was going on in her head never stopped. And keep in mind that no one ever came here and told you that insanity has to last for 5 minutes, 30 minutes, 2 days. I appreciate the prosecutor coming up here and talking about aggravated murder, but that argument is not a good argument. You don't need me to tell you that there was no prior calculation and design as it related to the death of Julian. You see how random she chose them, and that's at a spur of the moment. And no one can say what was in her head when she was in Volunteers of America. How is she going to tell you what was in her head in Volunteers of America if Dr. Knopfinger or Dr. West couldn't? Don't fall for that. The reason why I said the attempted murder, the reason why I say the attempted murder is not a good charge because the focus appeared to be always on Julian. Margot, to her credit, did what any good mother would do. She tried to save Julian's life. And she got stabbed in the process just one time. If Bianca wanted to murder her, she would have stabbed her several times. And I don't know what world they're living in when it comes to rage. Rage is not 1, 2, or 3 stabs. It's horrific what happened, but that's not rage. It's very important that you understand preponderance of the evidence. Please read that instruction. If it had to be quantified, more probable, the greater weight of the evidence, those are terms that you've heard, but if it had to be quantified, it's 51% to 49%. That's our burden, far less than what they have to prove, which we've conceded to a number of the counts for proof beyond a reasonable doubt. You cannot make a decision without considering that burden. I welcome you to have, in one hand, Dr. Knopfinger's opinion, and in another hand, have Dr. West's opinion, and see which one makes the most sense. You're going to see, when you have the jury instructions, you can just focus on me, then I'm going to go to his opinion. You're going to see words in the instruction that talks about, NGRI can't be motivated. So no motive. You know that there's no motive to take the life of Julian in this case. There's never been one established. Even though generally the state doesn't have to prove motive, you have to take into consideration what's in the jury instructions. We know that this wasn't some impulsive behavior. Margot did what she was supposed to do. She took her son to the store, was shopping. She did nothing to provoke Bianca. So there's no emotional response that can be identified through the evidence. There's no impulsive behavior. And again, the word rage is something that Dr. Knopfinger introduced. We don't agree with that. We don't agree that she demonstrated rage. We agree that her act was wrong. The opinions in this case between both doctors are not equally balanced. You'll see language like that as well. Again, put those opinions side by side. And I guarantee you that if you truly objectively read them, you'll understand that Dr. West speaks of the insanity aspect of this much better than Dr. Knopfsinger does, and it makes more sense. So, in his opinion, pages 35, 36, and 37, and he sort of speaks two ways about this. But on page 35, under 2A, he talks about how Bianca interacted calmly with staff through a window. She did not display any objective signs of her severe mental disease. I don't know how he would be in a position, based on the video that we saw, for him to make that determination. But he thinks that because he's a psychiatrist and his words are powerful, that you're just going to latch on to that, especially with these inflammable facts. He goes on to say in section B, she not appear distressed or internally stimulated in Volunteers of America. On the one hand, she's walking with strong purpose. She's got this rage, but she doesn't appear to be distressed. He goes on in section D, he talks about she still does not appear to be distressed, internally stimulated, or out of control. In the Giant Eagle surveillance videos, he says that Bianca was well organized in her actions, did not appear to be internally stimulated, hallucinating, or disinhibited. What's well organized about walking into a store with a knife in your hand, walking with a knife where everyone can see the knife, and just walking around aimlessly until you latch on to those two people? What's well organized about that? Again, in section E, he talks about how Bianca didn't report symptoms of severe mental disorder, nor display objective signs of severe mental disorder. That's not required. Otherwise, he would have cited that as being authority from the DSM-5. How would he know? And this requirement of her having to report her symptoms, it'd be fine if he identified some authority that they can all agree upon, but you will not see that in his report. We're on to page 36, under 3. He indicates that, and we've talked about this, the defendant approached the victims from behind, which indicates the defendant believed the victims would perceive the offenses were wrong. Again, just look at the totality of the evidence. Look at the knife in hand. When she first walks by them, the knife is not concealed. In section F, under 3, he talks about how she didn't announce her presence. I just want you to look at all these factors, and you tell me, even commonsensically, if this makes sense. Dr. Knopfsinger had the benefit of interviewing Bianca when she's medicated. She's better able to communicate. Never had the ability to interview her early on, like Dr. West. He's got the benefit of incorporating everyone else's reports into his own report. That's the reason why it's so long, amongst other reasons. Mr. Johnson's going to get up here and he's going to tell you about the not guilty by reason of insanity through Dr. West's eyes. And I would ask that you listen to him. And I appreciate your time. I believe that at the end of the day, she should be found not guilty by reason of insanity. Thank you.
Thank you, Mr. Mack. Mr. Johnson?
May it please the court,
Thank you.
State of Ohio, Polk County. Ladies and gentlemen of the jury, I too want to thank you because this was a difficult situation. And every last one of you paid close attention to everything that was displayed. You heard from experts. You've seen evidence. And you witnessed the painful details of a tragedy. But make no mistake, we're not denying that this tragedy happened. It's about understanding the mind behind the tragedy. We heard from doctors, psychiatrists. Everyone said something a little different. But you have to use your common sense and judgment. At the end of the day, we have the tale of two doctors, and it has to make sense. The law asks you to determine whether Bianca Ellis, at the time of the offense, was suffering from a severe mental disease or defect, and renders her incapable of understanding the wrongfulness of her actions. That's the legal standard. Now, Dr. West, Dr. Testa, they both seasoned psychiatrists. They testified through the throes of schizophrenia, paranoid delusions, disconnected from reality. These symptoms weren't new. We learned over the years, she's been going through this time and time again. We have jail logs. She's in different states. Behavior does not change because she's off her medication. Now, Dr. Nalsiviger says, well, that's not a part of schizophrenia. But when you look at the evidence, when she's unmedicated, she's not in her right state of mind. You heard from him. 3 people were assaulted at North Coast Behavior when she was not on her medication. Dr. Nalsinger dismissed these symptoms as self-serving. He said he relied on surveillance footage, jail calls. Look at how he interpreted those things. It's through a lens of skepticism. He told you, well, I looked at the video and I didn't see any signs. I didn't see anything where she was talking to herself, but I asked him, I said, well, there's no audio. It's not the best video. How do you know what she's hearing? No, based on the facts, I don't think she has any excuses for her behavior. And the problem with video is, when I slowed it down and showed him a still shot of her in the Things outlet, she was looking up and to the right. Well, that doesn't make sense. If she's going there looking for water, and I asked him, I said, well, water's not going to be up and to the right, is it? Well, no. Well, what if, I asked him, what if she's hearing something and she looks up to see what's talking to her? But he dismissed that. And I think he didn't slow the video down. Videos, when they're in constant motion, you don't see everything. The illness clouded her judgment. And she did not know the wrongfulness of her actions. Because we heard from Dr. West. She's a seasoned psychiatrist. She spent a lot of time with Bianca. We spent time together with Bianca. And the video you saw her in arraignment, that's the Bianca I met. That's the Bianca that Dr. West met. She wasn't in her right state of mind. But the person you see right here is not the same person. Why? Because she was medicated. Now, Dr. Nossinger said she scurried away from the scene quickly. And I asked him, I said, wait a minute. Let's look at the video. Let's bring it back. He said she rapidly walked away, trying to get away, trying to evade detection. But that doesn't make sense, ladies and gentlemen. She's walking with a bloody knife in her hand. She's not running. Now, you've seen her at the police station. You've seen her. She skipped down the steps rather quickly. So we know she can move at a fast pace if she desires to do so. But that wasn't the case after this. She walked away slowly. Mr. Bush pulled up and said, hey, you know you just stabbed that kid. It wasn't a rational answer. Shrugged her shoulders. You had to ask yourself why. What state of mind was she in? She didn't know she just did something wrong. These behaviors are also consistent with psychosis. Individuals suffering from schizophrenia may still follow commands and flee due to paranoia. We heard that from Dr. West. She told you, just because a person's in psychosis don't mean they can't follow instructions. Now, Dr. Nossinger said, well, these things are self-reported. He basically said, I take it with a grain of sand, but I didn't believe anything she said. But he said, you got to ask her because that's one factor that they look at. Well, she didn't say the right things. He made it appear that there's a playbook of what people with schizophrenia and people who are delusional are supposed to say when they commit a crime. Well, this is not the Browns. There's no playbook. She told him in that interview, you're going to have that interview back there. And she keeps saying over and over and over again, I blanked out. I heard voices. That skeptic eye goes, I don't think so. Not a good enough answer for me. But he said, Dr. Nelson acknowledged that's a key factor, self-reporting. But he didn't listen to her. He didn't take any of it in for his conclusion. He dismissed it. Now keep in mind, he had her longer than most people interrogate suspects. She's in a cold room for 3 hours, no water, no break, and he's pressing her. He's pressing her. Do you think she wasn't tired of sitting there wanting to go? Listen to the video. He introduced rage. He brought it up because he knows it's one of those elements in the law that you're going to read about that you can't use. Mr. Mack talked about the motive. Well, she was angry about this money. The fact that she walked past several people and didn't do anything has to mean something. The fact that when she walked in, she's swinging a knife around. That's not organized behavior. If you're planning to kill someone, you're not walking into Giant Eagle with a big butcher knife swinging, because it screams out, hello, what's going on? The sad thing is, no one in Giant Eagle even paid attention. I don't know if they was trying to avoid looking at her, trying to act like she wasn't there. She walked around with a butcher knife, and I'm thinking, who can walk through a store with a butcher knife and the police not be called? The police are less than 2 minutes away. I'm thinking, did Volunteers of America have loss prevention? She walked right past the cashiers and not even stopped to pay. No one called the police and said, hey, this lady just stole a butcher knife. So when you talk about this timeline, this is a sad sequence of events that somehow it could have been prevented, but it wasn't. So we're stuck with what happened. And what happened was a tragedy. And it wasn't because she wanted to kill someone. It wasn't because she set out that day to kill someone. She told you, and you can hear in the video, she goes, I didn't think I would throw my life away like this. I had other plans. I didn't think I would throw my life away like this because I had other plans. She wanted to move to Florida. She talked about Disney. I put in applications for Disney. Dr. West states in her opinion, with reasonable medical certainty, that at the time of the events on 6/23/2024, Ms. Ellis was suffering from severe mental disease, schizophrenia. That's just one prong. We know that because everyone talked about the one prong. We know for 10 years she was schizophrenic. But what Dr. West did was to listen to Bianca. She listened to her rationale behind what she did. She listened to her about saying there's voices. She talked about the suicide. You're going to hear all this. You're going to have both. You're going to have both reports there. You got to use your common sense and judgment and say which one makes more sense. A lot of the reasons that Dr. Nelson put out there, it didn't make sense. It didn't make sense. No one was trying to hide. No one was trying to run. He goes, well, when she got apprehended, she didn't say, the devil made me do it. She didn't say anything. That's a part of her disorganized thinking. When she got to the room the next day with Detective Jones, her mind was on, where's this debit card? Where's this money that they took from me? He cannot say with a degree of certainty that he knows what she heard or didn't hear. Because when you look at that still shot that's in our photos, she's looking up to the right. Something has her attention. She's not looking straight ahead. She's not trying to hide the knife. He said, well, she's hiding the knife. And like Mr. Mack said, it was behind her back. Her hands were on her hips. The knife was in her hands. Listen closely at her interview because she explains away everything, what she was thinking. But when she gets pushed, when she hears those words, well, I'm about to give you some pushback. She listened to the authority. She let him push back. At the end, and you're going to have Dr. West's opinion, she opined with reasonable medical certainty that the time of the incident, 6/3/24, Ms. Ellis had a severe mental disease, schizophrenia, and it caused her not to know what she was doing was wrong. Ladies and gentlemen, based on those facts, everything that you heard here today, you have no choice, and we'd ask you to find her not guilty by reason of insanity. Thank you.
Johnson, thank you. Last thing, Mr. Crowley, I will hear what you say.
Counsel for the state, Detective Ventris. Counsel for the defense, Defendant Ellis. May it please this court. Good afternoon, ladies and gentlemen of the jury. Our journey of the last week and a half is coming to an end. Our jobs as advocates in this case are coming to an end. And make no mistake about it, folks, we are advocates for each of our sides. But your job is just beginning. Though you have toiled with us for the past week and a half, you have traveled to this courtroom every single day. You have listened attentively. You have taken notes, some of you more than others. And at times, there was a bit of levity. But just because there was a bit of levity does not mean that this case isn't serious. One member of our community died on June 3rd of 2024, and that was 3-year-old Julian Wood. His mother, Margot Wood, was stabbed, and she survived at the hands of defendant Bianca Ellis. You know, folks, everyone has thanked you, each of you, for your time and your energy and for your effort that you've given us. We've imposed on you folks, and you have made the sacrifice in your personal lives for us. And your sacrifice isn't over yet. After I'm done speaking, the judge will continue to give you some further instructions, and then the case is going to be given to you, and it will be in your hands for deliberation. You don't have notebooks at this particular junction because, as you already know, opening statements and closing arguments are what we think, what we believe, not what you heard from that witness stand. If I say something in closing argument, or for that fact, an opening statement that you didn't like or you didn't agree with, you rely on your 12 collective memories, because that's what our jury system is about. It's about you and what you hear in this courtroom to make a determination between the state of Ohio and this defendant, Bianca Ellis. I am going to share just a few things with you that I saw and that I heard in this courtroom. And by no means am I here to misrepresent anything. I want you to rely on your 12 collective memories. Some of you have taken copious notes. What have you seen in this courtroom? What testimony have you heard? This courtroom has been your oyster for the past week and a half. You can believe some, all, or none of what has been testified to. That is your prerogative. You are the sole judges of credibility. I want you to use your common sense and your good judgment that you use in your everyday life to make a decision in this case. And I know that you will make a decision in this case. In opening statements, I told you folks to pay close attention to Bianca Ellis's actions. Mrs. Pateo stated in her closing argument this afternoon that the defendant, Bianca Ellis, killed Julian Wood and attempted to kill Margot Wood on June 3rd of 2024. 24. We told you from the beginning that the one principal issue in this case is not going to be who did it or whether she did it. It's the issue of legal insanity. What that encompasses, folks, is that this defendant, with a plea of not guilty by reason of insanity, is asking you folks to relieve her of her responsibility of accountability for the death of Julian Wood and the attempted murder of Margot Wood. If the state proves all the elements beyond a reasonable doubt, she's saying, hold on, folks. I was legally insane, therefore should not be held responsible. But you folks recall that the burden is their burden to prove those two elements of legal insanity by a preponderance of the evidence. That scale has to tip. If it doesn't tip, they can't have it. One prong is not good enough. You need to focus on both prongs of the test that have to be met. If you do not have the second prong, she is guilty of each and every count. You heard the defense tell you, yeah, she's guilty of the murder, folks, but not guilty because of reason of insanity. They don't have the aggravated murder. We have the video. You decide. You decide how she acted that day. And was she hearing voices? And by no means am I disparaging anybody's mental illness here. I want you all to believe me from the bottom of my heart, because there are folks that walk around us each and every day with mental illness, and they don't kill people. What were her actions that day? You evaluate those actions on June 3rd, 2024, because that's what the law says. No one is disputing that she has been diagnosed with schizophrenia since she was 19. Not Dr. Nossinger, not Dr. West. Nobody's disputing that. But the issue becomes, did it affect her so much that she did not appreciate the fact that she stabbed a 3-year-old twice and a woman once? I submit to you, she knew exactly what she was doing. And it took her 8 months to come out with, I was blanking out, I was hot. I'm not diminishing her illness, but keep in mind, the excuses came 8 months later. Look at her actions in Volunteers of America. You know, I think in this courtroom, folks, for the last week and a half, we've been playing semantics. Tossing, throwing, dropping. You decide. You decide what she did that day, because you get to watch her as she's picking out knives. She's looking at the knives. Which knife is better for me? This isn't something I made up. I didn't go out and choose that Bianca Ellis was going to be the next defendant that I prosecuted in my tenure at the prosecutor's office, which has been long. And I didn't pick the Wood family to be the victims of this case. I get assigned cases because defendants bring themselves into this courtroom. So you have the two knives, We can agree on that because we have video. So there's not much dispute about the video because then it becomes interpretation. Interpretation by the state, interpretation by the defense. At the end of the day, the only interpretation that is important is yours. What do you see on those videos? Because if we didn't have the videos, then that would be a different ball game. But we have the videos. You have her actions. When she goes in to Things Outlet, the knives are on her back. Yes, she's positioned like this, but the knives aren't swinging here at Things Outlet. She is looking around to see who she's going to pick on. She goes outside. She stabs a column to see the pliability of a knife. That is somebody who wants a good weapon. That's not somebody who's just hitting the column. And then she goes inside of Giant Eagle. And you determine, because she's thinking about it, it's like hunting, calculated, manipulative. She goes in and sees a child in a cart that can't get out of a cart because his legs are coming out, and a mother pushing it. Soon as she sees them, that about face is so quick and follows them. But then she's too fast for them. So what does she do? She holds back and waits for her prey to continue to move on, and then she follows right along. There's nothing disorganized about that. That is focused. That is laser focused, ladies and gentlemen. And then she goes into the parking lot. And you heard Mr. Stroud and you heard Mr. Bush. They have no stake in the game. They told you what they saw. Never was she talking to herself. Never was she mumbling. Yet she took a knife and she plunged it into the back of a 3-year-old. That's what they did see, standing over her. Over him, I'm sorry. You heard the medical examiner. She's got no stake in the game. She told you that that butcher knife went into that child's body 4 inches that severed the carotid and 4 inches that stabbed the lung. She walks away nonchalantly. She walks away not in the aisle that she committed the crime, the next aisle, and she walked with a bloody knife. When the police arrive, she follows commands. And during the interview on June 4th, she talks to Marjorie Jones. You, ladies and gentlemen, have to watch that video. And what do you see? What do you see in that video? And where is her focus? I disagree with Mr. Mack. When he says that Dr. West talks about this disorganization that she had. I thought she was pretty gosh darn organized about what she was doing that afternoon. And you know what, folks? Dr. West said that self-reporting is not enough because she co-wrote an article with Dr. Knopfsinger, who's been practicing for 30 years. And make no mistake about it, folks, he doesn't have a stake in the game either because he's testified for the state, for the court, and for the prosecution. professional. And when you compare reports, it's not about how many pages it is. It's about the methodology. And you heard her. She agreed with me. Methodology is very important. Finding corroboration objectively is important. You decide, ladies and gentlemen. The defense wants you to believe that I want to normalize Bianca Ellis. I don't want to normalize anybody. Her actions normalize herself. Because like I said before, many people in our country suffer with mental illness every single day, but they don't go out and murder people. No one is going to stand before you and tell you that Bianca Ellis is not a schizophrenic. I'm not here to tell you that. She is. She was her own payee. She was living her own life, doing her own thing. Going to California, going to Florida, functioning herself. Nobody had a guardianship over her. You heard that. But on June 3rd, 2024, Bianca Ellis killed Julian Wood and stabbed the mother. It was aggravated murder all day, every day. The murder and the felonious assault, yes, somebody got hurt and then they died. That's murder. You have the interview of the 4th. You have all the body cams, all the videos. You have both reports. Ladies and gentlemen, at the end of the day, ladies and gentlemen, as this case is winding down, we recognize in a civilized society that we rely upon the recourse of the law. We owe it from one generation to the next. The recourse of the law requires that you find the truth. In finding the truth, it really requires that you have faith in yourselves and faith in the law. What your decision is in this case completes the accounting for the death of Julian Wood and the attempted murder of Margot Wood. You've been on this journey with us, folks. The recourse of the law instills in all of us responsibility. And we don't lose that responsibility by claiming that we were insane at the time. That balance is off, folks. If they don't meet their burden of proof, not guilty by reason of insanity does not exist, and you find her guilty of each and every count of this indictment. And I ask you that. I ask you that for our community and for the mental health community. Because good people sometimes make really bad choices, but they know what they're doing. Thank you.
Thank you. Just the board. You can leave the other. All right, so ladies and gentlemen, I'm going to now charge you with your instructions to go back and begin your deliberations. Because this is a criminal case, the law requires that all 12 of you be in agreement before you can consider that you've reached a verdict. For the 12 of you, one of you will be picked as a foreperson. I'll talk about that in a moment, but each of the jury instructions are redlined. These are the originals that need to be returned to me as the court. We'll give you an envelope to seal them in so that you can give them back to the court. I'll talk a little bit about the directions. So whoever the foreperson is, there are a couple things that I'll advise you of regarding your choice as foreperson. But before we even get there, you have heard some discussion about punishment, and that may have come in different ways. I don't think any of the lawyers brought that up, or any of the witnesses who maybe have brought it up as well, in any way to diminish my responsibility. But you may not discuss or consider the subject of punishment at all. It is only your duty to carefully weigh the evidence, decide all those disputed questions of fact that came through this witness chair, apply the instructions that each of you will have to your findings, and then render your verdict accordingly when you return the verdict forms. For the 12 of you, your verdict and efforts must be to arrive at a just verdict, right? Considering all the evidence, and then make your findings, and do that with intelligence, impartiality, without any bias, without any sympathy, without any prejudice, for or against the state of Ohio or Miss Ellis. Both parties come here, both the state of Ohio and Miss Ellis, both of them come here and believe that they will leave here feeling that their case was fairly and impartially tried by all of you. When you do go back to the jury room, upon your retirement, you will immediately proceed to select one of your number as the foreperson. That person will preside over your deliberations. Whoever that foreperson is, you're sitting in this room right now, hear me. You have no greater authority or power over any other member of this jury, except I'm charging you as the foreperson with the responsibility of ensuring that each of the jurors is given an opportunity to express their opinion on the evidence. Of course, the foreperson, when you've reached a verdict, you're all going to sign this and make sure that as the foreperson, they're filled out correctly. Doesn't matter what order you sign. There's 12 signatures. Doesn't matter that you have to sign in the same number or the same place. But just when you've reached a verdict, you'll sign the verdict form in ink, which agrees to the finding that all 12 of you have. Now, if you have a question about these instructions that I give you, it has to be discussed between the 12 of you first in the privacy of the jury room. If all of you disagree, or some of you disagree as to the meaning of the instructions, it may be possible, under certain conditions, to review those matters by a request to myself. Know this, if you ask a question of the court, I convene all the parties first. We have a discussion about the question. We may bring you back in here and have that discussion about your question here on the record. I may provide you something in writing. If I've provided it to you in writing, it's because the parties have discussed it. But just know that you send a question to me, it's not going to be answered immediately because I'm going to bring everybody back in for discussion about your question. But whoever the foreperson is, please write or print neatly, sign the question. That question is part of the evidence and stays part of the case. So once you sign it, date it, it will have the case number on it, and write me your question. We'll make sure we get it answered for you. If you desire to address any communication, again, as the foreperson, you must reduce it to writing, have it signed by the foreperson. And the question, again, is usually answered here in open court. And if I do give you something in writing, save the question and answer with the evidence. Again, after you've reached that verdict, you'll contact this room through Kathleen, and then your verdict will be read here in open court. After the verdict is returned, then you're discharged as jurors. Then you can discuss this case with anyone or not as you choose. But until a verdict has been returned here in open court, you may not discuss this case with anyone or let anyone discuss it with you. I'd like to go even like a step further. 11 of you are in the room. 1 of you is in the restroom. There's no discussion, right? You're not discussing the case when everyone is not present. So I give that distinction because it's very important that all 12 of you are present. Now, as alternate jurors, I am going to excuse you from the deliberation process as alternate jurors. When we recess, I'd ask that there be no discussions in that jury room until my 4 alternates have gathered their information or their stuff from the jury room and have exited the jury room. So you are not picking your 4-person until the 4 alternates leave. But for 4 of you, you still remain part of my jury. There is enough times in my career as a judge that there's a possibility that juror 1 has to step in for someone who's unable to fulfill their duties as a juror. So you're instructed for the 4 of you not to discuss this case with anyone. You're not to discuss what your verdict might have been or discuss anything about this case. When there is a verdict, we bring you back up into my courtroom so that you're part of hearing that verdict read. And then, of course, there are discussions that you can be part of afterwards. So when we're done here, I ask that you grab your belongings from the jury room. Ashley will bring you downstairs. We will have you down on the 4th floor, but we also take your phone numbers just to make sure that we put you on a group text and let you know what's going on when you need to come up. So again, grab your stuff and then leave. Again, you're still part of this jury. No discussions at all as we move forward. For the 12 of you, look, the law in constituting a jury of 12 jurors, it contemplates that each of you, all 12 of you, give your individual consideration to and upon the judgment in this case that you're going to render. It gives your individual consideration upon the evidence that came through this witness chair. The rules of law which are explained to you here in these jury instructions are binding upon each of your individual conscience and the judgment as members of this jury. While deliberating, please, each of you jurors should give careful consideration to the views which your fellow jurors have, even if it's not your decision or your thought process. A juror should not turn a deaf ear to their associate jurors. And then without listening to their reasons or their arguments, you obstinately stand upon your own opinion, regardless of what may be said by another juror or jurors. It must be the object of all of you to arrive at a common conclusion, and to that end, you should deliberate together with calmness, in a dispassionate manner, being considerate of each other's views. You should really have 2 propositions of equal importance in mind when you're deliberating. First, that the laws here are enacted for the benefit of all members of organized society. And when you as a jury are convinced beyond a reasonable doubt of a defendant's guilt, then you as a jury should say so in its verdict. And then moving to the second prong if you need to. Again, as a jury, being convinced by a preponderance of the evidence, you should say so in your verdict form if you find that. And secondly, that no defendant should be convicted of a crime when you, the jury, are not convinced of such defendant's guilt by evidence beyond a reasonable doubt. The verdict that you as a body reach is of your own. There is no right or wrong verdict as long as you've considered all the evidence that came from this witness chair, that you listen and follow the law that I give you, and as I have instructed you here this afternoon. And so I say to the 12 of you, ladies and gentlemen, this case is now in your hands for a verdict. If we'd all rise, please.
Dan DeRosa with 19 News. You've been listening to a very impassioned judge, Judge Russo. The case of Bianca Ellis and the murder of Julian Wood, just 3 years old, is now in the hands of the jury. It will be up to them to come back with a verdict, either guilty or not guilty by reason of insanity. I just want to keep my eyes on the courtroom here. The judge is going to have a sidebar with the attorneys, both the state and the defense. We obviously are not able to listen to that conversation, but I just wanted to make sure there's nothing further. There was going to be the question, would the judge send the jury home? It is 3:30. They might get in maybe a half hour, an hour of deliberation before they head home. But we are now on jury watch. There is so much at stake in this case. Julian Wood with his mother, Margot, simply doing what people do every single day, going to the grocery store to get dinner. Let's make sure there's no more further
As
instruction.
a judge, we all hold the same professional degree, and I appreciate your respect for our degrees and for the professionalism in the courtroom. So thank you for this almost 2-week process that we've been at. That being said, I've given you an opportunity to review the jury instructions, and so as I read them, of course, I read them as correct as I can, and so I just want to know if there were any objections to those jury instructions from the state of Ohio that I've shared with the jury today.
No objection, Your
And
Honor.
on behalf of Ms. Ellis.
No, Your Honor.
All right, very good. I know we all have your numbers. I know you all have busy schedules. You're going to be going somewhere else starting tomorrow, if not in 5 minutes, to some other courtroom. But at least remain in contact with Kathleen so that if we have a question or we have a verdict, that we can reach all the parties as well. Anything further then before we recess? State?
No, Your Honor, thank you.
Thank you. Anything from the defense?
Just off the record, sidebar, Johnson.
All right, very good. Then we'll adjourn with respect to the case. Thank you.
And that will do it. They're going to have another little sidebar, but they are adjourned for the day, which again means we are on jury watch. How long will it take? I have spoken with 2 defense attorneys as a part of our team coverage. Both don't seem to think that this will take very long because they really just have one question to determine, one question to answer. Was Bianca Ellis insane at the time of the murder? Not just mentally challenged, mentally health challenged. Was she insane at the exact moment that she stabbed Julian Wood and Margot Wood, of which she is now accused and facing aggravated murder, attempted murder, child endangering, theft, and felony assault charges? We are obviously going to be on this every step of the way. As soon as we find out there is a verdict, whether that be today, obviously pretty unlikely, unless the jury gets back there and takes a vote and wants to work late, that could technically happen, but more than likely in jury deliberation day 2, day 3, day 4, however long this takes. As soon as there is a decision, that's why it's so important to have the Cleveland 19 News app. You will get a push alert saying that a decision has been made and the announcement will be read in court. They generally give a half hour to an hour for all parties to get back to the courtroom. It has been a draining, exhausting, and painful journey into the second week of this trial, but we are closer to the end than we have been before. We will be on it. Watch for our team coverage. Our 3.5 hours of news and first alert weather are currently on Channel 19 right now. So I say, until we have a verdict, I'm Dan DeRose with 19 News. Have a good day.